अभी करता हूँ। ಬಂದಿದೆ.
Comply. It will come the preliminary hearing. You're moving it for preliminary hearing? Preliminary hearing. So, hmm. What is the matter about? It will come on Wednesday. Bill number 25. You appear for? Appellate counsel this matter next week. Next week. Yes. ಏನಾಯ್ತು? ಅದೇ ಏನಾಯ್ತು? ಆಯ್ತು ತಗೊಳ್ಳೋಣ. ಹೇಳಿ. ಹ್ಮ್ ಹ್ಮ್ You appear for Yatish. Senior counselor. So his name appears in the cause list. Yatish. Yatish is a senior counsel. So say he's your senior. Don't say it is a senior counsel. Yes. At request of the responding counsel, this matter next week. Hersi. Second list, yes. Third list, I don't. What is this? What was the time bond given? One direction to the we said in the light of the same, the question of issuing mandamus to the respondent with prayers as sought in the petition would not arise before this court, with liberty to urge all the contention in review petition. Review petition, how can we direct them to dispose of?
That is the second respondent. But that's not total changes.
What is that you saying? Review petition, eh? RP tane? Ah,
Before that, RP and RP will be better.
no, we said,
We filed is
no, we said the mandamus which you are seeking, we cannot be granted in light of the review RP pending. You have to urge all your contention in the, that is also a passed an order, Mr. Consul. No orders necessary on being spoken to. No, Mr. Consul, mandamus ಕೊಡಲ್ಲ ಮತ್ತೆ direct name ಕೊಡೋದು ಅವ್ರಿಗೆ. No, we said as the review petition is pending, go and urge all the contention before the RP.
What will happen there?
There cannot be both two proceedings.
For previous renewal, since I'm asking for
Represent, we said it's not
percent
possible.
renewal, was for percent renewal of the.
I can't. Rule 5. Why? Hmm. Hmm. See, now as per the notification, Gram Panchayat, they say, you say, ಅಲ್ಲ ನಿಮ್ಮ ರಿಟ್ ಪಿಟಿಷನ್ ನೋಡ್ಕೊಳ್ಳು ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲ 17 ಪ್ಯಾರಾ 17 ಬನ್ನಿ ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ ಪ್ಯಾರಾ 17 ಬನ್ನಿ ನಿಮ್ದು ರಿಟ್ ಪಿಟಿಷನ್ You have filed a statement of objections, right? Also, the building is situated in a Gram Panchayat limits. ನೀವೇ ಹೇಳ್ತೀರಾ ನಾಟ್ ಇಲ್ಲ ಎಲ್ಲಿದೆ ನಾಟ್ ಹಾ ನಾಟ್ ಲೈಕ್ CMC ಅಂತ
ತುಂಬಾ ಚೆನ್ನಾಗಿ ನನಗೆ ಲೈಸೆನ್ಸ್ ಕೊಟ್ಟರು ಲಿಮಿಟ್ಸ್ ಅಲ್ಲಿ ನಾನು ಲೈಸೆನ್ಸ್ ತಗೊಳ್ಳೇಬೇಕಮ್ಮ ಒಂದು ರಿಲೈನ್ ಲಿಮಿಟ್ಸ್ ಕೊಡಲೇಬೇಕು.
This court is only asking whether this ground which you have urged in your para number 17 is indicates that the building is situated in a Gram Panchayat. If you file your objection additional, respondent is allowed happily. CGP 6 to file additional statement of objection. With this 2 weeks time is granted.
Number 3, ready.
What is this? Yes, Mr. Reddy. By third time you have to take, then after that. So MY Lokesh appears for the respondents have entered. Where is M Lokesh? It is brought to the notice of this court that the E order WP 18806 is brought to the notice of this court that respondent number 7 and 12 in this petition are the petitioners in WP 49589 of 2014. Is it so, right? In light of the same, Learned Counsel MY Lokesh is directed to accept notice for respondent number 7 and 12. Yes, next. Memo for treating 10B and 11B as legal heirs of deceased respondent number 10A and 11A. Na? Any objections for that? Memo filed by the petitioner is accepted and taken on record. Respondent number 10B is treated as LR of respondent number 10A and respondent number 11B is treated as 11 is treated as LR of 11A. Petitioner to amend the cost title and file amended cost title within a week. Yes. This matter on the matter on 25th. Yes. What is this? Await service of notice. Notice on I number 1 of 20. ಇವ್ರು ಯಾರಿಗೆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ? ಅದು ಇಂಕ್ಲೂಡಿಂಗ್ ಗೆ ನೋಟಿಸ್ ಹೋಗಿದ್ದು. We have already issued notice on 7/8/2024.
Those is such a big, but instead of the notice for the hearing.
Issued notice to whom?
Proposed respondent.
ಅದೇ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ವಾ? Which ಬೇರೆಯವರಂದ್ರೆ ಯಾರಿದ್ದಾರೆ? We issue urgent notice to respondent number. Proposed respondent. Yes.
Number 5.
Yes. Representation on behalf of the petitioner, to which time is granted to rectify the office object. And we'll take this matter after some time. Yes, we will take it up after the orders and the admission. One ಸ್ವಲ್ಪ ಹೊತ್ತು ಆದ್ಮೇಲೆ ಹೇಳಿ. First is hearing ಎಲ್ಲ amount ತಗೊಳ್ಳಿ. ಅವರೇ ಹಾಕಿದ್ದಾರಾ? I-1 of 2024 is filed to condone the delay of 733 days in filing the NR application of deceased respondent number 1 by the legal representatives themselves. ಹೌದಾ? ಅವರೇ ಅಲ್ವಾ? I-2 of 2024 is for setting aside abatement. I-1 of 2021 is to bring the LRs of deceased respondent number 1 on record as respondent number 1 A to C. Which occurred. Reasons indicated in the affidavit accompanying the application is accepted. Delay of 733 days is condoned. Abatement is set aside. LRs of deceased respondent number 1 are permitted to come on record as respondent number 1 A to C. Yes, appellant to carry out amendment and file amended cost title within a week. What about R2?
R2, my lord, in the website shows that my lord, R2 is served. Yes. But the second time is served, my lord.
Second time he is served, huh?
Served. Item delivery confirmed and
Confirmed, huh? Details not found ಅಂತ ಹೇಳ್ತಾರೆ.
The RK details shows for item delivery confirmed.
There, it shows track consignment is details not found.
Website in the High Court website only, my lord, item delivery.
ಅದೇಂಗೆ? How can there be two? This is done by the registry, and that is done by the postal department. So that is not served. Petitioner appellant is granted a week's time to do the needful in respect of unserved respondent number 2. Yes.
Number 2, 3. He and common.
What are they? No, now he has already filed an application to bring the. So, death certificate.
I didn't produce it.
You have served the death certificate.
Yes, I have seen it.
Do it during the course of the day.
Yes.
With appellant counsel to rectify the office objection raised by the registry on I number 1 of 24 to I3 of 24 during the course of the day. Office to verify and proceed. Now, who has filed this memo?
The High Court order.
Who has filed this memo for retirement?
The earlier previous secretary has filed the memo.
Now, will anybody file wakalat for respondent number 10? Memo of retirement filed by the counsel G.
His name is already deleted and his name is.
It's a counsel R10. So look into the cause list, right? We have filed only power for respondent number 1 and 2. Right? Move for retirement is acknowledged by the maker. Retirement is filed by J.P.C. Learned Counsel appearing for respondent number 10, along with the letter issued to the respondent number, along with the letter issued to the respondent letter and the acknowledgement for having served with the notice of retirement on respondent number 10. The memo of retirement is accepted. Learned Counsel, MC Jayakirti is permitted to retire from the case as counsel appearing for respondent number 10. Issue court notice to respondent number 10, returnable by 15 days before. 1510. It was extended earlier. What is if the matter is admitted or not admitted? Drawing of final decree. Okay.
Yeah, because the appellant has the purchaser of the property in the year 1983. So they filed after year 2001. So cancellation, the count for consideration.
This court has admitted the appeal on. There is also a final decree stayed until further orders, but then you kept on extending the order. On 7/2/2017 by framing substantial question of law. The interim order of drawing up a final decree is stayed until further orders by this court on 7/2/2017 itself, and hence extension of the interim order would not arise now. Since B.B. Sidramaya has filed power for the appellant, the name of Girish P. Baldare, Learned Counsel, to be deleted from the cross list. Yes. At request, a week's time is granted to do the needful in respect of unsolved respondent number 6 and 7. Yes. What is this? Who has expired? Murthy CLN. Aurilva. Idain application. What is this application you are recalling? You have filed wakalat? When did you file wakalat? Sir, when did you file? In 4 weeks. Huh? ಮತ್ತೆ, who are you? Who are you? You are the colleague of Murthy. Huh? Have you got instructions to file wakalat? Yes. So and so counsel submits that he has instructions to file wakalat for the appellant. At request, a week's time is granted. Furthermore, the learned counsel so also submits that Murthy CLN learned counsel is no more. And the learned counsel has instructions to file wakalat for the appellant. At request, a week's time is granted.
Appeal for appellant in this case, my lords. Could be granted 2 days time, my lord. I will comply the officer prescription, my lord.
Counsel, 50 rupees you are unable to pay.
I will pay today, my lord. I will pay today, my lord.
Itself, compliance of the office of petitions in regard to the process fee and the deficit process fee to be done during the course of the day.
Much obliged.
What is this issuance of court notice in respect of A1, A3 to A6? Okay. A court notice is to be ordered or it is ordered? What is that? Issuance anta ಹೇಳ್ತಾನೆ. When was the notice issued? And they have filed power only for some of the appellants. No, court notice is not ordered. Issue court notice to appellant A 1, 3 to 6, returnable by. Yes. Paper book typed copy ಅಂದ್ರೆ ನೀವೆಲ್ಲ xerox ಹಾಕಿದ್ದೀರಾ? How is it permitted, Mr. Madam? How is it permitted? Then we'll dispense filing of paper book, but you can't file the xerox. That is already available in the original. Why we ask for a paper book? We ask so that it is legible for us to see. Alva. We can allow that up. I-1 of 2021 is filed to condone the delay of filing the LR application of deceased appellant number 2. I-2 of 2021 is for setting aside abatement. I-3 of 21 is to bring the LRs of appellant number 2 on record, LRs of appellant number 2 on record as appellant 2 A2 to C. A2A to C. Learned counsel for the respondent has no objection to allow the application heard. Reasons indicated in the affidavit is accepted. Delay is condoned. Abatement is set aside. Allowance of deceased appellant number 2 are permitted to come on record as appellant number 2A to C. Appellant to carry out amendment and file amended cost title within a week. And the compliance of office objection raised on the paper book is overruled. Yes. Returnable by 1510. Amendment during the course of the day. The counsel for the appellant submits that needful has been done in respect of the issuance of notice to respondent number 1 to 4. Office to verify and proceed. Then counsel for the appellant submits that amended cost title and filing of amended cost title, amendment of cost would be done during the course of the day. Office to verify and proceed. How many recallings you have filed? Oh, three orders. How many orders you are seeking for recalling?
One order is talking about 17. The AMT order was passed by the Sanabad court, submission was not complied. Is that the production of separate copy of the report order?
And what is 11/4/2017? ಇನ್ನೊಂದೇನೋ ಇದೆ ಅಲ್ಲ? Why do so many applications? What is 11/4/2017 order?
It's also for recalling.
Agree. You are seeking for a recalling of an order dated 11/4/2017. What is 11/4/2017 order?
The AMT order was passed.
And what is 27/4/2007/2014 or 17 order? There are two applications, three applications. Whose affidavit you have filed?
The big affidavit appending 2017 is representing the.
And you took so many years to only recall this order. You had already filed this application. You could have moved this appeal. Is it not? When did you move? You have complied the office objections now. Pending consideration of the application for recalling. The registry is directed to permit the appellants to rectify the office objections. Why they have settled? Memo is filed by the appellant, which reads as under. The memo is taken on record. The appeal is dismissed as withdrawn. Yes.
And I'm appearing for the appellant, my lords.
There is many whatsoever. Yes, what is this memo reporting death of?
R3 is dead, my lords. And steps must be taken against him. So I kindly pray for time to take steps. We are not joint family, we're not living together. And we have no relationship with the respondent number 3. Hence,
What is
My
your
lady?
name? When somebody is arguing, why are you on saying as per whatever you want? You should at least know if somebody is addressing an argument.
sorry, my lady, the mic is not on. I cannot hear the respondent arguing.
Yes. When did he die? 19/4/2020. Then he is defendant number 2. For the transport and the construction network. Defendant number 2. He is defendant number 2. They were all sailing together.
No, my
Where is the genealogy of the parties?
My lady, in the trial court, they were placed ex parte.
This is my lady. Who is my lady? What do you mean by my lady?
It's Lord and Lady. We address as
Ladyship.
Lords for the male, and then it's tradition
Can't
in the UK.
address the court as lady. You can't address a court as a lady. You need not call my lord, you need not even call my ladyship, but don't address it as my lady. Please. Oh.
They got a lot. It's not depend on one vintage. Vintage will depend on all the faster independence. One gate to B minutes don't one A minute is first line minute of vintage. Then the second line minute and the C minute and D are the children of vintage through them.
Yes.
But R2 minutes is the brother of vintage. Now minutes they find minutes that they got is them.
Right.
In fact, these two minutes pertains to the minutes between the 95 depend number 1. In respect of the property which is 1 minutes by vintage. I am seeking share minute. The client is seeking share in respect of the property.
Okay, there was a partition between this Venkate Gowda and Siddhe Gowda.
Share minute in respect of the property which is by vintage. First by
You file a memo stating that this respondent number 3, he says, 3 is not a necessary party. We'll now say it is abated because he has died in the year 2020. Memo is filed reporting death of respondent number 3 by the appellant. Respondent number 3 is dead, is reported to be dead on 19/4/2020. No steps have been taken. Appeal stands abated as against respondent number 3. Post this matter for final hearing. Yes. Thursday.
My lady, after 1 week, kindly I'll take steps regarding the memo. My
Don't
lady.
address the court as my lady.
Sorry,
Yes.
I'm extremely sorry. The thing is, the respondent number 1, 2, 3 and the appellant were brothers. I mean to say,
Correct.
the appellant's
Was
father.
seeking for the plaintiff is seeking for the share in the dependent number's property which had fallen to his share. Is it not?
Yes, please.
Where is the
Yes,
necessity for the defendant
No,
respondent
the-
number 3 to be a party to this
There
proceedings?
are additional joint family properties of
File a memo.
respondent number 1, 2 and 3, Your Honor.
Yes. You want to continue this partition suit for a longer time. So let it be. Let us see. Ah.
I'll file the necessary application, Your Honor, for kindly 1 week time.
You
Maybe.
can leisurely file whenever you want the application. This court will not wait for you. If you want, you file. We will pass orders on 26th. Yes. Yes, finally. Nothing final for final hearing. Yes, next. It was dismissed for non-compliance. Pending consideration of I number 2 of 2019, registry is directed to permit the appellant counsel to rectify the office of. Yes. When did he die? Filing a memo. Memo is filed by the appellant stating that the respondent number 7 has died issueless. The memo is taken on record. In light of the memo, the taking step to respondent number 7 is dispensed with. Yes. This is the matter for admission. Next week. Date for it. Yes, next week. What is this? Dismissed for what? Appeal was dismissed.
Accommodation will be given to.
Who is given? Who are you?
Akshapras Naik is given to CH-27.
Where is his name?
We are yet to file the wakalat.
So you are filing wakalat. So and so counsel submits that he has instructions, that so-and-so counsel has instructions to file wakalat for the appellant after obtaining NOC. At request, a week's time is granted. Mr. Anep now,
I am appearing for the, I have had a memo for retirement of the, in the, on behalf of
Now-
appellant.
now
Now
who is
my, P. Mahesh is appearing on behalf of appellant in my place.
is memo for retirement filed by Ramesh B. Anapnagar is accepted. Since P. Mahesh has filed, learned counsel has filed power for the appellant. Accepted. Registry to delete the name of Ramesh B. Anapnagar from the cause list. Appellant is granted 2 weeks time to rectify the office objections.
Much obliged.
Yes, Mr. Rupesh. Bring the deceased respondent. Respondent, huh? And what is the office objections? Notice ಹೋಗ್ಬೇಕಲ್ವಾ? The office objection raised by the registry, ಅಷ್ಟೇ ಇರೋದಾ? Registry is overruled. Issue notice, issue emergent notice on I number 123 of 2020 to the proposed LRs of deceased respondent.
Number 16, Rajesh Athiyan.
A4.
A4 appellate purpose. I filed wakalat on behalf of the lot of the application for bringing the lot of A4 appellate 4 has been filed.
ಅಷ್ಟೇ ಮತ್ತೆ ಇನ್ನೊಂದೇನು I4
R1 ಗೆ ಅದನ್ನು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ. R1 ಡಿಸೀಸ್ ಆಗಿದ್ದಾರೆ ಅವರು ಎಲ್ಲ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು ಅವರಿಗೆ.
You already filed wakalat for the LRs of respondent number.
No.
We'll allow their LR application for appellant number A4 we will allow because after that the notices. Respondent counsel acknowledges the receipt of I number 1 of 24 to I3 of 24. Hence office objection stands overruled. Issue how much is the delay?
180 days.
180 days. I1 of 24 is filed to condone the delay of bringing the LRs of deceased appellant A4. I2 of 24 is filed to set aside the abatement. I3 of 2024 is to bring the LRs of deceased appellant number 4 on record. Then in counsel for the respondent, caveat has no objections to allow the application. Third, reasons indicated in the affidavit is allowed, delay is condoned, abatement is set aside, LRs of. So respondent number 2, no objections by respondent number. Abatement is set aside, LRs of deceased appellant number 4 are permitted to come on record. Appellant to carry out amendment and file amended cost letter within a week. Yes, issue notice on I number 1 of 2022 to 4 of 2022 to the proposed LRs of deceased respondent number 1. Yes. No? What is the suit for? What happened to the suit? Dismissed. So this is the plaintiff's appeal. Your contention is? Allah, it's a prior partition or it's a self-acquired property? Now the trial court has dismissed. Now whose name has been entered? Whose name was there? Respondent number 1's name was there.
There is no stay order in this case. However, entry says this stay order.
You have to go to the authority and say. No, how can
They also disconnected the power connection.
for that different cause of action, right? You have to file a writ petition to that effect. So whatever, correct. If there is an entry in the revenue records without there being any stay order, you have to seek for rectification of the revenue record.
Of course, we consider
Then,
this. Or we would do.
correct, but there is no stay order. You take the order sheet, place it before the appropriate authority.
It is still.
Take all this ground, make a ground for rectification.
Quite on that. So unfortunate.
Correct. Now we cannot rectify this revenue. Yes, yes. You go before the appropriate authority and seek for removing of that entry, and you know what you have to do in respect of electricity. Yes. Next.
Undertaking is given by London Fed has been continued till today.
What is the undertaking? Then there is a stay, alva, amele. One second. Where's the order?
My lord,
The grant.
my lord, undertaking given by London Fed, my lord, on my lord, the 24/3/2017, my lord.
Not to cut the trees.
Not to cut the tree. That is the undertaking has been given. My lord, I have produced the photograph. I have produced the photograph. Your lordship may kindly see the photograph. They have cut the trees. Immediately we approach the Salma court and honor the court. They don't cut the trees. That is the undertaking can be extended, my lord. Otherwise, they will clean the property. That is why they have given the complaint also. Police complaint before the.
The matter has to be heard for admission.
Please, my lord. I don't know. My lord, at this stage, I will not press anything, my lord. That undertaking till serving comes into the LRs of R1 to be continued, my lord.
Taking of your respondent. Who is no more.
They cannot say, my lord, other. My lord, you will not see the photographs, what action they have taken. When the fact is pending people.
Who was the counsel appearing for respondent number 1?
He was my Leonard Friend was the counsel, my lord. No, he cannot say that I will not appear for R1.
It's a submission of the respondent counsel.
Yes.
That he would instruct his client not to cut and remove the trees.
On behalf of the respondent number 1.
No.
That is not forthcoming in the order. It doesn't come coming in the order. So as of now, don't do anything. We'll list this matter for admission.
Please.
Don't do anything.
Please.
Now there is an interim protection to the petitioner appellant.
I did not well deeply.
That's all. That's all. That is the interim order which is
They have entered a state.
that you can seek for clarification. The interim order granted by this court on the undertaking of the learned counsel for the respondent on 20th March 2017 is extended to the next date of hearing. And yes. What is this awaiting service of notice? When was the notice ordered? Yes, await service of notice in respect of unserved respondents. What is that? The office objections raised. What is the office objection raised? Please check it. What do you want this court to do? Correct. There's some compliance which there's been notified by the registry. So you have to comply that. What do you propose to do? Yeah. Then what do you want this court to do? Correct. Notice has to go to them. Before that, you have to comply the office objection. Just look into that. Appellant is granted a week's time to rectify the office objection based on I number 1 and 2 of 2024.
But in this case, The notice to respond number 1 is not required, my lord. On 6/3/2023, I have already reported that R1 is dead and she is a spinster and order has been passed, my lord. 6/3/2023.
Learned Counsel 6/3. Learned Counsel for the appellant brings to the notice of this court that the notice to respondent number 1 would not arise as she has died without leaving any legal heir. Stop. And in light of the order passed by this court, furnishing of process fee to issue notice to respondent number 1 would not arise.
And delay may be condoned, my lord, and it may be posted delay of only 2 days, my lord.
Yes. I-1 of 2017 is filed to condone the delay of 2 days in filing the appeal. Reasons indicated is accepted. Delay of 2 days is condoned. Yes. Accordingly, I-1 of 2017 is allowed. This is the matter for admission.
Much obliged, my lord.
Yes.
Sir,
What is to be?
for
What is to
appellant
be?
discussion. Can grant 1 week time, my lord. I will furnish a fresh address, my lord.
A week's time is granted to do the needful in respect of unserved respondent number 2B. Yes, Mr. Varaprasad.
Needful done, your lordship.
Appellant counsel submits that needful has been done. Office to verify and proceed. Kalburgi bench. Hey, Kuri. What bench is that? Kalburgi bench. Please verify on regular list. You will be intimate from him. The matter pertains to Kalburgi bench. Registry to do the needful. To whom? Memo is filed seeking dispensation of notice to respondent number 5, 19, and 20. Memo is taken on record. Notice to respondent number 5, 19, and 20 is dispensed with at the risk of the appellant. Next. Where is the office objections? On what office objections is that? And what paper publication you're seeking for in respect of respondent number 21? I-1 is filed to take paper publication in respect of to take substituted service by way of paper publication in respect of respondent number 21 and 23. I-1 of 24 is allowed. Appellant is permitted to take out paper publication in Kannada daily newspaper, Kannada Prabha Hasan edition on or before and show the date of appearance as the 30th October. In the meanwhile, the appellant counsel is appellant counsel to rectify the office objection raised by the registry on I number 1 of 2021. Yes.
Number 23, the Shankar ATC.
Substituted service. Ah.
3 times notice were issued to respondent number 1 and here IA is filed for seeking the paper publication.
R2, na?
R2.
I-1 of 24 is filed for substituted service in respect of respondent number 1 and 2 by way of paper publication. I-1 of 24 is allowed. Appellant is permitted to take out notice by way of paper publication in Kannada Prabha, daily newspaper, Kolar edition, in respect of respondent number 1 and 2 on or before. So the date of appearance and yes. You have any objections?
Lower court they got stay. They are wantedly, they have not filed.
No, these applications, you have any objections to allow the applications to be?
That's right. Delay only I will file next time.
ಇದಕ್ಕೆ delay ಗೆ LR application. See, until we allow this, you will not be permitted to come on record. So you should not have any objections to this LR application. I-1 of 2023 is filed to connote the delay of 319 days in filing the LR application, setting aside abatement, and to bring the LRs of deceased respondent number 1 on record as respondent number 1A to D. The proposed respondents have been served and they are represented by counsel. Learned counsel has no objections to allow the application. Reason stated is accepted. Delay of 319 days is condoned. Abatement is set aside. LRs of deceased respondent number 1 are permitted to come on record as respondent number 1A to D. Appellant to carry out amendment and file amended cost title within a week. What is that? Not allowed on Saturday, according to I-1. Interim order was not extended. It has not been extended since 2023. What copy ಬೇಕು ನಿಮ್ಗೆ? Please serve him whatever he wants. Yes.
35, say Rajaram.
You take notice for. Why do the government don't appear once the notice has been issued? ಇಲ್ಲಿ ಬಂದ್ಮೇಲೆ ನಾವು ಹೇಳ್ಬೇಕಲ್ವಾ? You said 1, 2, 3 na ಎಷ್ಟು ಎಲ್ಲರಿಗೂ ನೀವು appear ಆಗ್ತೀರಾ? SCGP is directed to accept notice for the respondents. Appellant counsel to serve the appeal papers on the learned counsel. Along with I-1 of 2019. But ಅದು serve ಮಾಡಲ್ಲ ಅಂತ ಹೇಳ್ಬೇಡಿ. ಎರಡು serve ಮಾಡಿ. Yes.
26, Sri Gandagarappa AV.
What is this early hearing application? Yes, sir.
Last time, it was observed with an understanding that I should go on with this today. I am making submission for this board. Unfortunately, the paperwork was misplaced. Today morning, I was able to find it again. Either it may be next week or any day.
Sport has got convenience whole day. We are here. Sir.
One thing that
There is never convenience for the court. The court is always here. ಎಲ್ಲಿ ಹೋಗಲ್ಲ ನಾವು.
one thing I would like to say. For partition.
ಗಂಗಾಧರಪ್ಪ ಅವರೇ ನಿಮ್ಗೆ ಬಹಳ ಬೇಡ ಅದ ಅಪೀಲ್ ಪೇಪರ್ಸ್ ನೋಡಿದ್ರೆ ನಿಮ್ಗೆ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ. ತಗೊಳ್ಳಿ. On the last occasion also I think this court mentioned the same.
Suit was filed for partition. It was decreed in part. Against which second defendant filed one appeal, the plaintiff filed another appeal. Both the appeals were posted before different courts. Courts were not informed about the pendency of the other appeal to any one of the courts, and both the appeals were not clubbed together. Two different judgments have been passed. Matter has to go to the appellate court for reconsideration of the entire.
Plaintiffs and defendants 2 to 5 The first appellate court held that they are entitled for equal share in the suit property.
Another court has said that the parties are entitled to separate set of shares.
Equal Allah.
Equal.
We will say how they are entitled. Now ಹೇಳ್ತೀನಿ. If it is there, we will attend. ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ ಅಲ್ವಾ?
It has to go for
We will see. We will see if it is the quantification, how the quantification has to be arrived. You say that it's your self-acquired. Huh? What is your contention?
My contention is that in view of the provisions of Karnataka Amendment Act.
ಅದೆಲ್ಲ settled ಈಗ. Nothing is there now. If it's only quantification, we will not remand. Alva, Mr. Gangadharappa avara.
We will call tomorrow. I will make it. Tomorrow. Or it could be called next week.
Tomorrow we will complete this. ನೀವು ಇಷ್ಟೆಲ್ಲ ಓದ್ಕೊಂಡು ಬಂದಿದ್ದೀರಾ ಮತ್ತೆ ಯಾಕೆ ಬಂದಿಲ್ಲ ನಾಳೆ tomorrow. Monday we take other appeals. Monday, Tuesday, Wednesday we take writ. ನಾಳೆ Saturday ಬನ್ನಿ
Saturday I got an appointment with
ಮತ್ತೆ ನಾಳೆ ಬನ್ನಿ ಅದ ಎಲ್ಲ ಆರಾಮಾಗಿ ಐ ಆಪರೇಷನ್ ಮಾಡ್ಕೊಂಡು ಆರಾಮಾಗಿ
ಆಪರೇಷನ್ ಏನಿಲ್ಲ
ಆಯ್ತಲ್ಲ ನಾಳೆ ಬನ್ನಿ.
Sir, if you are in possession, you will have to.
See, if it's your contention that in light of this Karnataka amendment, they are not entitled for equal share, then that you know. Now in ಹೇಳೋದೇ ಬೇಡ. You know what is the proposition of law.
Quantification
ಅಷ್ಟೇ. ನಾಳೆ ಬನ್ನಿ ಇವ್ರೆ, ನಾಳೆ ನೋಡೋಣ. ಏನು ಆಗಲ್ಲ ನಮ್ಗೆ ಏನಾಗಲ್ಲ. We have already heard ಏನಿಲ್ಲ ಇದ್ರಲ್ಲಿ ಇದ್ರೆ ನಾವು ನಿಮ್ಗೆ ಹೇಳ್ತಿದ್ವಿ ಎಲ್ಲ ಓದ್ಕೊಂಡ್ ಬನ್ನಿ ಅಂತ. ಇದ್ರಲ್ಲಿ ಏನಿದೆ ಓದ್ಲಿಕ್ಕೆ? ಹೀಗೆ ಕೊಡಿ ಒಂದ್ ಕಾಪಿ ಅವ್ರಿಗೆ. ಇದೆಯಲ್ಲ ಆಯ್ತಲ್ಲ ನಾಳೆ ಬನ್ನಿ tomorrow. ನೀವ್ ಹೇಳಿದ್ರಲ್ಲ ಏನಿದೆ ಅಂತ ಅಷ್ಟೇ ಇರೋದು. ನಾಳೆ ಬನ್ನಿ. ಏನಾಗಲ್ಲ ನಾವು ಮರ್ತು ಹೋಗ್ತೀವಿ, ನೀವು ಮರೆಯಲ್ಲ ನಾವು ಅಲ್ಲ ನೀವು ಮರೆಯಲ್ಲ ನಾವು ಮರಿತೀವಿ ಫ್ಯಾಕ್ಟ್ಸ್ ಅನ್ನು. ನಾಳೆ ಬನ್ನಿ ಇವ್ರೆ, ನಾಳೆ ಬನ್ನಿ tomorrow. 26th. As a final chance. At request of the appellant. Yes, what is this?
We have 6 days for filing.
Any objections? I-1 of 2017 is filed to condone the delay of 6 days in filing the appeal. Reasons indicated in the affidavit is accepted. Delay of 6 days is condoned. Accordingly, I-1 of 2017 is allowed. Yes.
Admission.
It's a matter for admission. Concurrent findings, Bunny. That is the common grievance of the appellants, Alva.
That is.
16 date Korea. Date 26 now. Yes. This is the same condoned. Next matter condoned. This is the matter for admission. Notice ಹೋಗ್ಬೇಕಾ? Notice on the legal recalling ಏನು ಅದು? You have complied. You have complied the office objections. When did you comply?
19/7/24. Only the number of days delay is.
Scored on 11/7/2024. Granted the appellants 2 weeks time to rectify the office objections. Pending consideration of I-1 of 2020. for recalling the order dated 8/11/2020. The appellant has rectified the office objections as per the note submitted by the registry. I-1 of 2022 is filed to recall the order dated 8/11/2020. The reasons indicated in the affidavit is accepted. The order dated so and so is recalled. Subject to the appellant paying cost of rupees. ಎಷ್ಟು ಕೊಡ್ತೀರಾ? ನಿಮ್ಮ association ಕೊಡಿ, clerk association. And on that day, no. There are 3 months granted to you to rectify the officer. ಸ್ವಲ್ಪ ದುಡ್ಡು ಕೊಡಿ. 1,000. 1,000 ಇದೆ. 1,000 to be paid to the advocates association, again, the clerks of benevolent. Within a week. Yes, issue notice on I number 123 of 2019 to the proposed loss of respondent number 1. Returnable by. And other respondents issue emergent notice to the respondents on I number 1 of 2017. And to the proposed loss of respondent number 1 on I number 123 of 2019. Yes. What is this? Pleading? Applicants. Why? You are the pleading applicant. One nimsha. Recalling is what? Steps not taken in respect of? ಈಗ ತಗೊಂಡ್ರಾ? The appeal was dismissed as against respondent to A to D for not taking steps. Which was that order?
17/7/2000.
I-1 of 2023 is filed to condone the delay of 571 days in filing the recalling application. I-2 of 2023 is filed to recall the order dated 17/7/2019. On 17/7/2019, there was no representation on behalf of the appellant. However, finally, 2 weeks' time was granted to the appellant to take steps in respect of respondent number 2A to 2D and 4 to 14, telling which the appeal stands dismissed. The appellant has taken steps to the said respondents and counsel and the said respondents have been represented by the counsel. In light of the taking steps by the appellant, this court deems it appropriate to recall the order dated 7/7/2019 by condoning the delay of 571 days in filing the recalling application, subject to the appellant depositing cost of rupees. ಎಷ್ಟು? ಹೇಳಿ. 1,000. Yes, 1,000 to the clerks association benevolent within a week. ಆಮೇಲೇನು? Is in light of the recalling of the order, the registry to verify regarding the wakalat filed by GB Manjunath. ಈಗ ಎದಕ್ಕೆ ಬರ್ಬೇಕಿದು? Is the matter? In pleading applicant in, what is this? You were not a party before the trial. And
Properties.
you file your objections. Appellant to file objections to I number. I-1 of 2024. Without permitting them to file objections, how can we allow your application? You are not a party. We have to look into. We have to look into the merits of the matter. Is it not? Correct. Let him file his objections. ಇಷ್ಟು ದಿವಸ ನೀವು ಬರ್ಲಿಲ್ಲ. Suddenly after filing an impleading application, you want to come on record immediately, right?
I went to Parliament property. They have made entry in the record.
We will see. Our objections ಹಾಕ್ತೆ by a week. Yes, next.
We can see the number one. Yes, Subramanya.
This court heard the appeal. This court heard. Then we are not. We don't know what. We don't know what transpired. Mr. Consul, we don't know what transpired, right? You may be right in saying that heard matter was heard. It has not been treated as part heard, alva. It is treated as part heard, illa. Is it treated as part heard?
Current funding, fail to prove not they can't have their property. Due to the pendency of this proof not property gifted to me.
Pendency, na?
It's observation, the trust owned by the observation matter was the courts. I filed application to not amount because I was not a party before I filed for the separate application.
So your right could be coming only if the other dependents get some share in the. Now you have proved the gift. There is a gift in your favor, right?
Yes.
Have you proved the gift? Validity of the gift?
Both the courts have transacted it is separate property. He has also right to give the property. That is the objection by the both the courts.
So your limited extent of coming on record would be only to the extent of prosecuting this appeal. Because your right is not yet established whether there was a gift or not.
It's a objection.
There is observation that there is a gift.
Both the courts have that note is valid.
There is a valid gift. Yes, Mr.
Before the appellate court, there was a direction to receive me the grant. But here, by the application, the applicant has filed a application to direction to deposit the grant here.
Before the court.
Yes.
Yes, deposited.
But application to modify that order. Application is pending.
Where is that application? No, we will consider this matter on merits. Yes, Mr. When you
The next week, without my.
So and so counsel supports that his senior is unwell. As the final chance, list this matter on 26th. For admission.
The Shankar DC.
Oh. Records have come, right? Records can be here. Okay. Ah. Just a moment. This 1935-36, what is it? Auction property. Yeah, who are you? You are the plaintiff or the defendant? Plaintiff. Plaintiff suit for partition and separate. 1 to 5 in favor of, when was the sale deed, when was the sale deed executed?
11/2012.
Sale deed. And when was the suit filed? Twenty days of execution. So defendant number 1, daughters of defendant number 1 filed a suit. That is, you are the daughters of defendant number 1. So you filed a suit for partition and separate possession, claiming 1/4 share. Correct. So
And the property was earlier belonging to the family. It was taken over by the government for non-payment of tax. The taxes have been paid by their grandfather. Restored in their father. All of the daughters are their names are not there. Therefore, it is not we wait for the genealogical print that was made available and purchase the property. And it is my case not it is also not marked as an exhibit D70 CD. But exhibit D70 is not that it is the property which belongs to the director. And all
exhibit D17 is what? The sale deed.
deed that can be executed by dependent number 5 in favor of dependent number 6.
Is it mentioned in the sale deed that this property is a joint family property? Yes.
As soon as I learned of the JD, immediately I made a suit for partition.
Yes.
I learned the undisputed practice that there were 2 other properties which were subject matter affected. On mainly on 2 grounds. There are other grounds also only the things can be used. Mainly on the ground that all the family members were not made partition. One ground. And all the other properties which were available in the family were not included. Therefore, a suit for partial partition is not included. Where the main grounds on which the High Court not proceeds to dismiss the suit. Apart from that, High Court would also hold that the result in the sale would be not much consequence. Because it is it appears that the city is dependent in the loan of it. Therefore, all these ones are High Court. All companies were left out. I filed an application for amendment. And also I filed an application not to include all the other family members who were left out in the these 2 applications, amendment application and the application for improvement, were taken up along with the merits of the appeal. On the merits of the appeal, not the trial court comes to the lower trial court comes to the that the 6th dependent is the lower court. And no zones have been made out as to why these properties are not included at the trial stage. And why these family members were not inducted as parties to the suit, the trial stage. Therefore, along with the merits, these 2 applications are not taken.
Where is that exhibit? What is that exhibit P1? Sale deed?
Exhibit D17.
And D17. What is exhibit D17?
The procedural was made available as genealogically excluding the names. And if it is it has come out with the evidence, not that we are able to produce it. We cannot produce it. That was the best document not which would show. It was the bona fide purchaser for value.
Who are the vendors there?
Vendors were dependent on.
That is Sanjeevappa, Venkatama, Savitrama, Gopal and Sharda. Sanjeev Appa is your father. Venkatama is your mother. Savitrama is your sister. Gopal is your brother. And then Ravi.
Brother, son. Jagat is brother, son. Gopal Krishna is my brother. Madhu is also my brother.
See, after all the brothers and Alva, one sister idare. This system, perhaps she must be staying somewhere. Alva, Alva. After ಈಗ ಒಬ್ರು 3 ಜನನು ಸೇಲ್ ಡೀಡ್ ನಲ್ಲಿ ಇನ್ಕ್ಲೂಡ್ ಮಾಡಲ್ಲ. No, this is how it goes. You know, Mr. Shankar Reddy, how it works. And immediately she is aware about the sale deed executed. Oh, as though she goes and sees the revenue records immediately. Sale deed ಮಾಡುವಾಗ ಎಲ್ಲ which place is this? Which place is this? Kolar. Bangalore influencer. Play. See, so convenient it is. Alva?
And he went for the genealogical tree and included all those names in the same deed. That was the best document that he could have made. In the course of evidence, he said, I haven't again. If that particular document is there, then not, he has taken all steps. You see that we verified that all the family members are joined in execution.
After selling the property, after doing everything, suddenly.
After a five not after a number of years. But then they would be as.
No. Both ways. Allah, both ways. Immediate to it gives you some different notion, and late also it gives you some different notions. Correct. The gravity ಬರುವಂತೆ. Mr. Shankar Reddy, kindly read where it is stated that it is internal page B. Whereas the vendors being the absolute owners, having absolute right and title over
About that. And of available by word. Serial number 1.
ಏನ್ ಅರ್ಥನೇ ಇಲ್ಲ. There's no meaning for the sentence only. It's all intentional drafting. Sit across and settle, Mr. Shankar Reddy. Otherwise, not a case for it. Otherwise, not a case for it. ನೋಡಿ work out. Just work out. Is it possible? That's what this court expressed now. That's what.
Vendors being the absolute owner. Vendors.
We will not say much about the sale deed. See, now he has already paid so much of amount.
Yes.
ಇದೆಲ್ಲ ಏನು all collusive. All the brothers, sisters together they come and after selling the property.
And not have included other family properties.
The appellate stage.
You need not, there's nothing additional cost for you for not including that property. Alva?
Chance ಇದರಲ್ಲಿ ಏನಾದ್ರು ಕೊಡಕ್ಕಾಗತ್ತಾ? ಆದ್ರೆ ಬೇಕಾದ ಹಾಕಿಲ್ಲ ನಾವು ಭಾಗ ಬಗೆಹರಿಲ್ಲ.
That is not the only ground for dismissal of it. Even assuming you have impleaded anything, what was your right and what was the right to claim a share? Burden was on you. Our burden, no? That is between your brothers. Between your brothers and you. How is this dependent number 6?
Also, delete not once the purchaser will delete and transfer to the family member.
Correct, correct. Now you settle with this dependent number 6 insofar as this property is. That's why we said settle it. Otherwise, it will not end here. It will never end here. There is again appeal provision for them. They will always go. So end the matter here. See, this court takes only 2 minutes to even do something in this appeal. But to give a finality to the or right to a party, it is better to see for a settlement if it is possible. Otherwise, we will pass on. Tomorrow only. You keep your party present. Tomorrow. Appellant counsel submits that an endeavor would be made to settle the matter amicably. In light of the same, looking into the dispute between the parties. The parties are directed to be present before the court tomorrow. You just 2:30.
The round is ready.
The round. Correct. Good for specific performance.
It's a present performance. They are the content makes, but they are under an agreement of sale. They take 26/5/2005. The total sale consideration is 1,62,500. According to them, they have paid 1,20,000 and balance repaid at the time of registration. Then further content came on 9/1/2007. The first development and sold the property they were considered. For subsequent purchase. How it depends the.
During the pendency of the suit, it was sold, right?
That is the suit is filed on 26. 2006.
Yeah.
And then 1/9/7/2007, the property was sold. Before receiving the notice from the court. And
When was it sold? Sold 9.
sold 9/1/2007. Suit is filed on 6/12/2006.
Kindly this. Yes, senior.
That 9/1/2007, before the sixth, they only by the first opinion. It's not the property of the second. The contention of the first amendment in radio statement read that.
Was there any agreement between you? Was there any agreement between you to sell the property? So there is no sale agreement.
There is no further. Then your lordship will see the first defendant is denied the execution of the agreement of sale. Then the second defendant has taken, and second defendant was treated as a party during the year 2008. And during the year 2009, he filed his written statement and that he is a bona fide purchaser. Then your lordship can see that the issues framed by the trial court, my lord, that the issue was not framed regarding the bona fide purchaser. Page 42. The issues. Before filing of the written statement by the second defendant, 5 issues were filed. Regarding that, whether they have executed the agreement of sale, whether the plaintiff has proved the sale.
The role of defendant number 2 is very limited. He would join along with defendant number 1 to execute a sale deed in favor of the plaintiff. Whether he is a bona fide purchaser during the pendency of the suit, whether that has to be ascertained by the trial court on the first appeal. Once then agreement is held to be proved, nothing survives. It is only for the defendant number 2 to join with defendant number 1.
Here your lordship is the problem is, lordship can say, why this court has framed this issue, lordship can say, I shall issue lordship.
Yes.
Whether the second defendant proves that the first defendant along with his sons has sold the social property in his favor for a valuable consideration under the recent deed dated 9/1/2007 for a legal justice and put him in possession of the social property.
Framing of issue itself is a bona fide purchase.
Yeah, but there is no findings on this issue. Your lordship can see the last paragraph, last page of the judgment. Issue number 1, 2, 3. First findings. Then your lordship can see at page 73. After giving the findings on issue number 1, 2, 3. Page 73.
Yes.
The first line, under such circumstances, I answered issue number 1 and 2 in the affirmative, and issue number 3 and the additional issue dated 4/11/2009 answered in the negative. Here, in the beginning, your lordship can see a taken an issue number 1 and 2.
Though specifically issue number 3 is not been reasoned by the trial court. If you look at para number 37, 38 and 42, the reasons have been assigned as to why he is not a.
Issue number 4, government. Issue number 5.
Issue number 5(3).
But in that reason that the issue number 1, 2, 3 was given a reason. But issue number 1, there was no reasoning.
Though the trial court did not mention in particular about additional issue, while giving reasoning, it has given at para 43 notice.
Very good. Honorable.
Invoice number. Page para 43, page 72.
On the other hand, the DW1 to DW4. I have been a cross-examined with the evidence for the plaintiff, suggesting with regard to entire case of the plaintiff, with regard to oral and documentary evidence, for which he has denied the same. Though they have denied the said session, they have not put forth any defense at their cross-examination. Thus, being from any angle, the first defendant has to try to prove that exhibit P1 is created and concocted. On the other hand, the plaintiff has proved his case with oral and documentary evidence against both the defendants exhibit P1. And moreover, the second defendant has not cross-examined the plaintiff with regard to his defense that he is a bona fide purchaser of the social property. And further, the oral and documentary evidence relied by the plaintiff is not challenged by the second defendant in respect of the social property. And therefore, under such circumstances, the sale deed marked exhibit P7 and exhibit P6 dated 9/1/2007 executed the first defendant and his sons in favor of second in respect of social property. For legal justice and put him in possession of the suit provision, he cannot be accepted. Therefore, I may say that defendant number 1 has no independent right to execute this sale deed. They admitted this property is their ancestral property. They had 2 sons. That one son is a major and one son is a minor.
How do you get a right in the property, defendant number 2?
Defend number two, lordship, you can see, because all the family members have executed the same in favor of defend number two, but they are all right over the property. If defend number one alienated the property or executed in this, only limited extent his share can be executed. Here, your lordship, is the answer to the property, his sons are happy, right? The executed agreement of sale that was not considered by the trial court.
Was it raised? This contention was raised in your
Yes,
written.
it is the answer to property. Even in the agreement of sale, your lordship stated that. Even in the second executed in favor of defend number two, that is clearly stated, is answer to the property because of in favor of my son as well as this minor son, I am selling this property. All of them have been. When he had no independent right, your lordship will say that the issue should be right after the findings has to be given. Because of that reason, your lordship will say one point is my lord that the issue regarding the bona fide purchase was not fair, but the other issue was not that is he has no independent right to sell the property. It was also right. Because of that reason, it has to go back to the right one. Then one more thing your lordship can see, though issue was not fair, the first of the court has taken a view that he is not below the benefit. Because only the decision was executed during the pendency of this suit. Here, your lordship can see the sisters have filed a suit for partition. That is, the judgment was filed along with the application before the first of the court wherein your lordship can see the judgment, wherein the issue was framed regarding the bona fide purchase. As court comes to the conclusion, it is a bona fide purchase. Because your lordship can see, in view of this cannot, there is a conflict of purchase by the different court. Because of that reason, that document was not considered even after 41-27. Because that reason also your lordship must go back to the judge. The lordship will see the findings in the suit for partition, notice number 573 of 2007, that was filed along with the application in the first amendment court. It regards Procedural and sure, already sure, whether the fourth amendment proves that he is the bona fide purchaser of my. So, their findings and lordship will see affirmative.
Yes. Yeah. On page 19, regarding your findings and para 22, that overall consideration of overall document evidence based on record from both sides, and in the light of the admissions of Peter Lima, I have the clear opinion. When was the suit filed? When was the suit filed? 2007. And
It is also, the suit is also filed in 2000, that is December 2006.
you did not mention to the court about the specific performance suit being filed by the. Did you bring to the notice of the trial court the partition suit?
But this document was produced for the first amendment court.
Which document?
This is your judgment.
Correct. This
But about
document.
41 rule of
When you filed a partition, you should have brought to the notice of the court that there was a suit for specific performance
there
filed.
are two partition suits. The brother was also filed a
Whatever
suit.
litigations are there, you should bring to the notice of the court. Until then, how is the court going to be aware?
The notice of the Supreme Court.
Did you mention it in the order? Is the order mentioned?
Can say. The second defendant has brought to the knowledge of this court in his written statement.
Yes.
Sharadam and others filed a suit in voice number 579 of 2007 for hearing in this court. That was brought to the knowledge of the trial court.
Yes. Yes.
The Lordship against the judgment of the Honorable Supreme Court regarding the independence of the suit in the property was only been Page 7, the first judgment, my lord. Page 7, para 16. The Court of Review will consider certain other aspects as well. The date of the above mentioned decision of DWR. The attempt to bring a new plea by amending the written statement that the second defendant had purchased the suit property as per the people said dated 5/10/2000 as to the same. Since admittedly they indisputably the suit from which the appeal arises was one based on possessory title. The legal indemnity treaty shall need not be gone into these appeals rightly and not be gone into the court. Evidently the court declined to act upon the same. The right of the doctrine of dispayment, even if it is taken for granted that the provisions of the section 52 of the Transfer of Property Act are not applicable, as such in the case of hand, it cannot be disputed that the principles contained in provisions is applicable in the case of hand. Well, I settled position that whatever Transfer of Property Act is not applicable. Such a principle in the said provision of the said act is based on justice, equity, and good sense is applicable in the given similar circumstances like courts, etc. Then your lordship made the other decision.
It is against you. It's against you.
Which is
Transfer of possession.
therefore the import of section 53.
The transfer of possession pendente life will also be the property within the
It
meaning.
has to be served on the defendant number 1. The lordship is saying all it has to be done. All it has to be.
It is not the
So
purpose.
given we are filing of a suit for the court, then how can they know either the defendant number 1 or defendant number 2 is processed or filed a suit? They denied that the execution of the agreement itself. They denied the execution of the agreement itself. You are filing of the suit, it will not affect section 52 of the Transfer of Property Act.
Thus, this judgment says that merely pendency would not suffice, but notice has to be served. Only then it is it.
Lordship is not served.
Does the judgment
Lordship
say?
date is garnishing. The date of filing.
What does section 52 say? List pendants ಅಂತ ಹೇಳ್ತಾರ.
Dependence on the dependence in the
List pendants ಅಂದ್ರೆ ಏನ್ ಹೇಳಿ? ಅಲ್ಲ senior counsel. List pendants ಅಂದ್ರೆ ಏನು?
Dependence in the very
ಅಲ್ಲ, what is during pendants?
If you brought to the knowledge of the party, there is a counsel. The lordship.
Common sense is.
Otherwise, your lordship will see somebody has made a show. Whether he has had a period or not. Then your lordship will see that someone is not.
When the question comes of bona fide, that is different. Then the 52 attraction.
The act in section says that during independence episode.
ಅದೇ ಇಷ್ಟು ನೋಟಿಸ್ ಸರ್ವ್ ಆದ್ರೆ ಅಷ್ಟೇ ಬರುತ್ತೆ ಇಲ್ಲ ವಿಲ್ ಆಲ್ಸೋ ಸಿ ಯಾವ್ದದು ಅಂತ ಆಯ್ತು ಇಶ್ಯೂ ನೋಡೋಣ ಸೊ if the parties have understood and gone into trial, the question of framing issue would not arise. ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಮಿಸ್ಟರ್ if the parties went on trial knowing about the actual dispute between the parties, an additional issue is already framed in so far as that contention of defendant number 2 is concerned. And they went and they let in evidence, and there is a finding recorded by the trial court to that effect.
So what is this issue was where your lordship is not about the issue is whether the defendant along with his family members have executed this sentence. What the sentence shows, lordship in this clearly mentioned. All the family members have executed this sentence. This is not a proof, but not a lordship can say.
Yes.
But the court comes to the conclusion it is not to prove the issue. But it is sure by the court.
If you come to the, where is that judgment you said? Notice Adra Ashte. Where does it say?
The next judgment your lordship is next is your judgment your lordship in page 16.
Yes.
Wherein the issue has to be paid. But the contention taken.
That is all settled, Allah. Adella settled. Next. Yes, yes.
Page 29 and para 27.
29.
Para 27.
Ah.
The learned suggested that even according to our 14th of CBC, the court has to pronounce the judgment on all issues, notwithstanding that the case will be disposed of on a particular issue around 14th of the court of CBC.
Yes. Next.
Around 43 your lordship.
What?
Page 38. Framing of issue is a very important step in the civil litigation. And it is the role and duty of the court that you pay caution, diligence, and attention must be controlled by the running to the judge by saving law. At the same time, when your lordship will see any judgment. The lordship will say this is at page 44. My contention is your lordship will say that the defendant or mother has no independent right to sell the property. And without having a title over the property, he cannot sell. But at para page 44, at para 4. Then Babulal Kaur had two wives. Savitribai, the first wife, the daughter, the first wife. Sundarabai, the second wife, gave birth to 4 sons. So on to the Ashabai and David Babulal died and Sundarabai and the pregnancy initially are there. It's appeal but there. Ultimately, page 46, 7. Here is the issue that's there. 1B, issue number 1B, because the laws are having a right to take to sell. Within the margin in filing from the court, para 16. Consequence title of the property belonging to Mayor did not pass under the state certificate, even though the father was there. It will go on no Indian debtors. The verdicts on the Great Court and Better and Court holding so on, they were perfectly valid in respect to the court, there is more in the same by applying its own nation, notions and because it is a findings and fact of law. Here also, the Lordship can see as no independent right to sell the property.
Yes. So 3 contentions: non-framing of issue and non-considering of that issue. Pendente light purchaser, as the notice was not served upon him, he cannot be termed. So you cannot be treated as a pendente late purchaser.
Yes.
Notice not served. And thirdly, the joint family property
Joint family property.
has been sold and the suit for partition has been decreed granting shared credit.
Where in the findings says, that I am about to make purchase. Because I am also party and that party.
You have not made the agreement holder as a party when you knew that the suit was pending.
This does have findings, so.
Yes.
They should have met this,
Correct.
because.
You were-
because the logic
Allah, you were a-
that I have not sold it.
Correct. You were a party. This MP,
I'm a party.
you were a party. Then
Yeah, I am a purchaser because of the send it was the student money.
Ramesh was a party there.
Ramesh with the purchaser, because he is having the send it, that send it was executed by his father or house.
When a party is before the court, they should bring to the.
Lordship, you are right. Lordship can say, you know that there is an agreement of sale. Because all of them are.
Why Ramesh knew that there was an agreement. He should have got it.
Ramesh can knows only 2008 when he was imprisoned. The agreement was executed during the 2006. If I know the agreement of sale, then I should not purchase this property. Why I have to purchase this property? Because you want to have no knowledge.
Yes.
Because even number one, even in his written statement, he has said, I have not executed the agreement of sale. Then thereafter, Lordship gives the court comes to the conclusion regarding the of evidence that the agreement is true. Then the last point, they have no independent right to execute the agreement of sale because it is the property of us. That's all.
Not to alienate. The non-communication of the interim order does not mean that there was no interim order. And what you say about the partition? Ah. 34. Illala, which judgment you have? The present suit. So the sale. So sale deed also is executed by only few of the. Right. Naturally, they will dispute when they are seeking for shares. 34.
That is the stated order. They dated 9 of the which are one and the same. Whereas exhibit B7 and B6 clearly reveals that the cost of credit along with the as executed the sale deed, in favor of second inheritance and all of the are not executed.
And against the order of partition and grant and holding that the purchaser is a bona fide purchaser, did they file any appeal? No appeal. So you are satisfied having held that he is a bona fide purchaser. RSA.
So like 21 only execution, participated, in which notice was served upon them, they participated.
They participate.
That also they have appeared to an advocate and it has been computed a question also.
Tomorrow for dictation. Third, senior counsel for the appellant and counsel. That is there by our High Court also. Your communication is not relevant. Once an order is passed, it's an order. It need not be served upon the other side. Tomorrow for dictation. Yes. There is a possibility, right? The counsel for the appellant submits that the parties have amicably settled the matter and would report settlement by next date of hearing on 26, based on 26. On 30. Not 30th, 1st October. Is it possible 1st October? It's after vacation. Second. Date. You tell the date.
The parties are not for Bangalore. 16.
16. Money, second. Yes, madam. Party in person. First year.
So many things the product is set off. Second matter.
It's very easy. First year. Yes, yes.
The second case, that is fine by me. They are paying more than 5 minutes. But this case may be vacant.
I would pay for it. This is 1687 is yours. This is his petition.
Order will not pass. Restricting his claim of 7,85,000 to 42,77.
Really?
But first of all, 2009.
Correct.
7,85,000. But I'm giving also his direct. Sorry, pastry. As per his claim, I'm expected from his claim statement.
So his claim is this. 7,85,000.
They cannot contest with this case. That is up to 16, 10, 2015. Second claim. This came to be allowed as against the claim of 7,85,000. 42,781 was given. I think.
Correct.
Against which may not be before this.
Correct.
1,785,000. Why is not entitled to? When you see the page 3, I have given 2 references of 2 pages. We find 2 pages. But right from the beginning, I have given. Claim is from the date of his appointment till his supervisor. There are 2 cases we find. Reference 46 or 97,
Yes, sir.
whether the demand claimed by the Mysore Division versus Union for fixation of pay from 77 and arrears of service from the management is justified. Because this is answered, I have written this order also. The second party is directed to excel. Whatever the consequence events arise on the case of this party and that. Fixing the pay scale are part of HLA and shall pay all the money to the
So they are entitled for that fixation.
Then he files one more petition. There also is something. There is a demand claimed by the regularizing the services of Sri Ramaya from the year 1980 is the management of care services. And this is answered. The bus body government is placed on par with the duties which Lingaya electrician in the matter of safeguard, promotion, regularization, and other monetary requirements. So he succeeds in both the cases. Then this is the implementation. The next one is the implementation. But the corporation will not consider the probation date of probation of electrician. It was 82.
Yes.
Then Lingaya will not 84. Since Melod 82 was more beneficial to the petitioner, this was fixed.
Yes.
82. Then Melod earlier since worked out in as a government. That is, it is divided into 4 parts. A Melod, the earliest from 82 to 91. Because Melod from 82 to 91 he worked as a government. So some amount was paid, 70,354 was paid. The balance was 10,900. This A well. Then B Melod is arrears from 91 to 2005. This comes to 1,45,000. This is also paid. Then the next C Melod is the gratuity calculation. This is important. Your option is asking me the date of retirement.
Yes.
But the date of retirement is 2009. But then what happened? Files a petition, it files an application to the gratuity authority. Even before his dismissal order was not necessary, it was before this order. But when the case was being decided by the Labour Commission, this honorable court confirms the order of reinstatement. So therefore, the Assistant Labour Commission considered the entire period till its superannuation and granted the amount that is based on fine. 94,000, 9,440, 26 years, 10 months. Comes to 2,53,300. But in the order itself, for the amount of 2,10,520 paid to him has been extracted. He produced the next R7.
Yes, yes.
So directly to be paid when they have been taken. But if someone has been deposited and he has withdrawn the funds, but that I
Yes, yes, yes.
the photograph.
Yes.
But it's calculated in 98,879. So let us sum up A plus B plus C plus D comes to 4,89,900. Then the labor code under 33C considers this payment and holds that B and C. Therefore, it is not entitled, it is only entitled. Labor code said that 42,000
Gratuity.
if it is not paid, it is not paid. The next period is this dismissal. And this, there are 9 months when this case was pending for 9 months.
When this
other misconduct. Then the dismissal the dispute raised by the not rejected. The order of dismissal was upheld. It is which manner? Now I will come to this. This is important. 2 restrictions. Your lordship could see on the other day. I brought your lordship for this last matter. There were 2 restrictions. And I was not clear on which case not get challenged. 8757 of scrutiny. He claimed the relief of real estate. There was another restriction filed by him. This was clubbed. Both were clubbed. This was not detailed. Ideas of pay, medical leave, expenses to go into housing, uniforms, working shoes, and other available and other benefits. These 2 matters were clubbed together. And the expedition filed by him, claiming bonus and other benefits for this. And the order of the WP method, which was the question where is the order of upheld, that was modified. There was a direction to reinstate it, subject to the fact that the activity of service shall be upheld. So the additional benefit which you get is from 2005 to 2009. He retires on 8/4/2009. Then he files an appeal method against the denial of uniform allowance. Only method. The appeal is only against the uniform allowance. That's also rejected.
Claiming bonus was rejected, right?
Rejected.
And
The appeal also was rejected. He filed because it's a common order. Order passed the expedition. The reduced the financial R level
WP, so WP order of claiming bonus and another benefits were rejected. What happened? What happened to 8757 of?
They allowed in part by motion the respondent is entitled to development from the date of in the identity age of superannuation.
So that is also paid according to 2005 to 2009.
Page number 3, I have page number 4, I have covered the last gratuity calculations. Date of entry is shown as 29,580. Date of retirement is 2009. It is actually retirement. The controlling authority has been remained. That order is being filed. Now, now in the light of this, this claim,
Yes.
for the higher penalties. Now, if your options could come to my case filed by the corporation. The husband pending that he goes to the deputy labor commissioner.
Yes.
Seeks for stated labor.
So Deputy Labor Commissioner orders for
Recovery rate.
42,000.
So there is already an order and a certificate.
Yes.
So recover that, he claims a recovery credit.
Yes.
Recovery certificate is issued as per election, yes, madam. And as per election G, the special Tashika has been directed to recover the sum. Which is a question before your lordship. Your lordship would see not 5 of 2009. Only one line of the deputy labor commissioner and control. Page 43.
Yes.
Page 43, the last paragraph. ಸಹಾಯಕ ಕಾರ್ಮಿಕ ಆಯುಕ್ತರು ಮಂಗಳೂರು ವಿಭಾಗ ಉಪಗಣ ಪಾವತಿ ಕಾಯ್ದೆಯ ಅಡಿಯಲ್ಲಿ ದಾಖಲಾಗಿರುವ ಪ್ರಕರಣದಲ್ಲಿ 11,2010 ಆದೇಶ ಹೊರಡಿಸಿ 47,120 ಠೇವಣಿ ಶೇಕಡಾ 10 ಬಡ್ಡಿಯೊಂದಿಗೆ ಪಡೆಯಲು ತೀರ್ಮಾನಿಸಿದೆ. ಆದರೆ ಕಾರ್ಮಿಕ ನ್ಯಾಯಾಲಯ ಅರ್ಜಿದಾರರು 780 ಪರಿಹಾರವನ್ನು ಪಡೆಯಲು ಅರ್ಹರಿಗೆ ಮುಕ್ತವಾಗಿ ಆದೇಶ ಹೊರಡಿಸಿದೆ. ಆದ್ದರಿಂದ ಸಹಾಯಕ ಕಾರ್ಮಿಕ ಆಯುಕ್ತರು ಮಕ್ಕಳಿಗೆ ಹೊರಡಿಸಿದ ಉತ್ಪನ್ನ ವ್ಯತ್ಯಾಸದ ಮೊತ್ತಕ್ಕೂ ಈ ಮೊತ್ತಕ್ಕೂ ಯಾವುದೇ ಸಂಬಂಧ ಇಲ್ಲ. This is what he says, the Lord is. This 42,780 the labor code does not say that it pertains to assistant labor commissioner's order. Therefore, there is no nexus between this order and the order passed by the controlling authority. But now I take your lordship with the labor code order. I think on to page 18. The fourth point, the responding corporation has to exhibit RF, that is the order of the assistant company controlling authority order. Page 11/2010. This order reveals that the applicant has approached the assistant labor commissioner on 95, stating that the responding corporation is reporting for the purpose of it is last week was 26 years was the contribution benefit. It's pertinent to note here that the applicant has moved the application to the assistant labor. However, the second order was passed on 3 months ago. While when the assistant labor commissioner has rightly discussed that the applicant is not really the document to show that the pay was considering the last pay and other constitutional benefits added to this rate, considered this calculated and paid that the applicant is entitled to further, the assistant labor commission has also discussed in detail regarding what all payments made to the applicant and that only 42,780. However, it is important to know that the respondent was conducted and even the said amount was paid to the applicant along with interest, that is rupees 50,000. Despite this, before not finding by the labor code, by issuing recovery certificate, the deputy labor commission records their finding that the order that is passed by the labor code does not pertain to the order of the assistant labor.
So this is after the order passed by the Labor Commissioner.
Yes.
This is when 2018.
Yes. And had a doubt on that day, madam, because he was to the assistant labor depending on the Anisha being.
Anisha, yeah, Anisha.
Once the application whether are 95 on which they will not, did not have the order, benefit of the order, where is the order of dismissal was modified. Because the order of dismissal was modified 1 year after he filed his application. So the day on which he approached the controlling authority, he did not have, because his claim should have been only till 2005.
Yes, this annexure year was pursuant to what application? Annexure, no. This annexure year is filed for recovery.
Recovery of the amount that is specified at page 20.
But then having held, this is for 42,781 have been already paid by you.
The report says, where the amount if it is not already paid.
Correct.
All that I have to show is that I have already paid. And then when I say so, because it has been people in the proceeding, the recovery proceedings, stated as all the documents, the recovery officer will not come to the conclusion. This amount is different from.
But that is not the contention of the party in person. That is it. Where is
This
it?
time will not come. What happens if the party in person appears will not get and is also recovered. But earlier will not, where is the earlier from 1977?
Yes. Let him come, Allah. Let him come. Password, mother. But 1 minute. Yes. Continue. Third discussion. For dictation. For final hearing.
Case number 7, Sri Narayana Swami, DH.
Password.
Case number 8, case number 30.
क्या हो तो? When you law fraud ಎಲ್ಲ ಇದ್ರೆ it is for you to go before the civil court.
There cannot be any general proposition of law. What is called in the offending is the jurisdiction of the court of any matter determined and decided by any officer or authority and no granted in this case, the step 1, transfer of license under Rule 17B, after the death of master, that is done by an excise officer. Now, after the under single judge's order and I think given reserve key to move an appropriate forum.
No, we will not say anything about that. We will say, in light of the transfer license not being set aside or not being held against the respondent, the question of renewal of license being questioned by the petitioner would not arise now. No, correct. That is for the, if you want, you go and agitate before the excise commissioner. If it is not, if it doesn't do, you have to go before the civil court. We will not say anything about this now. So your contention we will take, but now in light of the transfer license being not being set aside or not been cancelled, so what remains is you cannot challenge the order of renewal of license. That's all. This is Allah. This is Allah, that's all. Let us not go beyond the scope. This will lead to another proceedings again. Correct. In the event if the excise commissioner says, Allah, in the event the excise commissioner says, now if we say, Mr. Bhatt, senior counsel, Mr. Bhatt, in the event if this court says, now excise commissioner has no jurisdiction, when that is not the issue before this court, if this court says anything about that writ appeal order also, that will affect any right in the event excise commissioner would adjudicate your matter. We may have to just say what the writ appeal court said, granted liberty.
So, this court of,
No, we will not say anything about better option was for you to file an application. Now we are with you. Now this from 1997 you were not given license, but now there is already a license in favor of them. Transfer license is set aside by any court now. It is not set aside. So now you cannot seek for renewal of that.
why did it get any court? Once it is entered, it should exit also.
You have to press that application there, and when they say it is not maintainable, go before. Yes.
Compensation may be prevented.
We can't go beyond what is there in the decision of the division bench, Alva.
Then give me the liberty, but for which?
But you should have sought for clarification, the event.
For which? Excellent place for assembly. Because delay not condoned. Delay in the exception not condoned.
No, that is a technicality. Now we cannot. Allah, correct. But we cannot say anything about it.
It's not binding upon anybody. Because don't condone the delay. That's my
That is available to senior counsel for the advocates to say. But this court sitting, we cannot say it is not binding.
Elder brothers, they will agree with me on that.
Even if we agree, not agree, we can't say anything. Yeah, that is what we read now. There is no absolute bar of the civil court. There is no absolute bar of the civil court. Under what circumstances civil court has to entertain? Before the excise come. See, you would have better chance before the civil court if you say it is fraud. Now, in light of the liberty, you can always go there. Do this. Kindly be seated. What did you say? In light of the judgment of the division bench? Huh? Correct. Renewal first is renewal. Second is we'll take up together. Petitioners in a writ petition. Which is the first writ petition or the first? The petitioner in WP 1978 of 2024 has called in question the order dated 18/1/2024 passed by the third respondent, Deputy Commissioner Deputy Commissioner of Excise, wide annexure R in favor of the Deputy Commissioner of Excise, BUD -2, as per annexure R, renewing the license of respondent number 4. Next one, WP 4159 of 2024. Has the petitioner has called in question the order dated 31/1/2024, passed by the third respondent, same number, as per annexure W, permitting the respondent number 4 to shift the location of this business, bar shop. Heard Sri G.K. Bhatt, learned senior counsel for the petitioner, and Sri P.R. Ravishankar, senior counsel for the respondent number 4, SCGP for respondents 1 to 3, and produced the material on this. These facts leading to the filing of this petition are that paragraph. The husband of the first petitioner and father of petitioners 2 to 4 was holding license in form CL2. The husband of petitioner, father of petitioners 2 to 4, one S. Jaishankar, was holding license in CL2, in form CL2, and was running a retail liquor shop at premises number 203, Arabic College, Post Venkateshpura, Main Road, Bangalore. The said Jaishankar died on 9/2/2024 in a road traffic accident. 9/2/1997. 9/2/1997. In your petition, it is mentioned as 2024. Yes. In a road traffic accident, leaving behind the petitioners as his sole surviving legal heir. It is the contention of the petitioner that the Deputy Commissioner of Excise, respondent number 3, without taking steps to transfer the license in terms of 17A of the Karnataka Excise License, C bracket nulli, General Conditions Rule 1967. Licenses 1967. In favor of the petitioner, and without their knowledge has transferred the valid license in favor of one Srimati K.R. Savita. Has transferred the license in favor of one Srimati K.R. Savita by order dated 36/1997. The petitioner coming to know about the fraudulent transfer in favor of Savita approached this court in WP 50353 of 2019, seeking relief to quash the order dated 36/1997, transferring the license in favor of KR Savita, and for a writ of mandamus directing to transfer the license in their favor, in favor of the petitioners. In the said writ petition, as the petitioner contended and explained, the delay in approaching the court and with regard to the fraudulent transaction, an order was passed by this court in WP 50353 of 2019 on 26/2/2021, regarding the fraudulent transaction by the Central Crime Branch Police regarding the fraudulent transfer as contended by the petitioner. The inquiry report was submitted by the Assistant Commissioner of Police, Central Crime Branch, coordinate bench of this court. After hearing, allowed the writ petition. The operative portion of the order reads as under page 110. respondent was not permitted to make an application as the order at annexure R1 and R6 was in operation, and the proceedings to withdraw the license of this respondent was initiated, and the same was withdrawn as per the order at annexure R6. Learned senior counsel for the respondent number 4 would immediately contend that the division bench of this court has granted liberty to the petitioner to approach the competent courts of law, forum or authority, and the petitioner are at liberty to seek such remedy as may be permissible under law. That the petitioner having accepted, the petitioner having accepted the judgment of the division bench cannot have any grievance against the renewal of license of the respondent, as they have to get the transfer order in favor of transfer order in favor of K.R. Savita set aside, and then only it is permissible under law to proceed against the respondent for against the renewal of license. Learned senior counsel submits that the petitioner has no local standing to file the present petition, questioning the renewal of license in favor of the respondent number 4, when the transfer of license is not being set aside and the order of the division bench having been accepted. Now the petitioner cannot raise an objection for renewal of license. Learned senior counsel would contend that the decision pronounced by the court is final unless that has been modified or reversed by the appellate authority. And in the instant case, the division bench of this court has dismissed the prayer sought by the petitioner on the petitioner, and that order has attained finality. In support of his contentions, learned counsel seeks to contend the principles of res judicata and the cause of estoppel, cause of action estoppel, inverted commas, and places reliance on the decision of the apex court in the case of Bhanu Kumar Jain versus Archana Kumar and another, reported in 2005, Part 1, SCC 797. 2. Hope Plantations Limited versus Taluk Land Board, pre-made, year made, and another reported in 1999, Part 5, SSC, Fine 90. Having heard the learned counsel for the parties, the point that arises for consideration is whether the petitioner is entitled for any relief as claimed in the petition in the present facts and circumstances of this case. The court has carefully considered the rival contentions urged by the learned counsel for the parties and produced the material on. The division bench of this court in writ appeal referred by K.R. Savita and respondent number 4 against the allowing of the writ petition in WP 50353 of 2019 filed by the petitioner seeking to cancel the transfer made in favor of K.R. Savita and seeking for license in their favor. The division bench of this court observed that the petitioner in WP had approached this court in WP 50353 of 2019 after a delay of 22 long years and observed that the delay cannot at any stretch of imagination be accepted as a justifiable explanation or reason. The division bench of this court observed that para number 18 as under page number 120 of the opinion. And further observed that the directions issued by the single judge in WP number 503 to conduct inquiry to the Commissioner Excise by Department of Excise, that too on the basis of the report submitted by the Assistant Commissioner Police by virtue of the order dated 26/2/2021 cannot be sustained as such, and the inquiry would be one without jurisdiction. The division bench further observed that and clarified that the authorities under the Act 1965 and the rules framed thereunder would be entitled to initiate any inquiry with regard to the violation of provisions contained thereof in respect of transfer of license, and further observed that the order would not foreclose legal remedy or options, if any, available to the petitioner before the competent courts of law, quorum, or authority, and the petitioners are at liberty to seek such remedy as may be permissible under law. While observing so, the division bench of this court set aside the order in WP 50353 of 2019 and the consequent orders. In light of the setting aside of the order in WP, what remains is that the transfer license, which was challenged by the petitioner in the said aforementioned writ petition, has not been set aside by any court of law. In the said circumstances, the grievance of the petitioner against the renewal of license of the respondent number 4, without seeking for setting aside the transferred order in favor of Srimati Savita, is unsustainable, and the petitioner cannot proceed against the respondent without there being a cancelling of the transfer order in favor of Savita. Yeah. Savita. The petitioner in the earlier round of litigation in WP 50353 of 2019 sought the following prayers, page 34. The relief sought by the petitioner has been set aside, which was granted in favor of the petitioner in the writ petition has been set aside by the division bench of this court. And there is a transfer license in form CL2 standing in the name of PR Savita. The apex court in the case of Bhanu Kumar Jain has held at para number 18, 20 and 21 and 29 as under. Cause of action estoppel inverted comma has been defined in the said decision, that is that which prevents prevents a party to an action from asserting or denying comma as against the other party comma the existence of a particular cause of action comma the non-existence or existence of which has been determined by a court of competent jurisdiction in the previous litigation between the same parties. Full stop. If the cause of action was determined to exist, that is, judgment was given on it, comma, it is said to be merged in the judgment. If it was determined not to exist, comma, the unsuccessful plaintiff can no longer assert that it does, comma, he is estopped from per rem judicata. The Learned Senior Counsel placed reliance on the decision of this court in the case of K. Balkrishna Rao versus State of Karnataka and others reported in ILR 1998, Karnataka 4150. Contend that the liberty was granted to the petitioner to approach the appropriate authority, and the civil court had no jurisdiction, and there is a bar to the civil court. There is a bar to the civil court as there is a remedy available under the Act. In the decision of K. Balkrishna Rao, the division bench of this court has held at para number 16 as underlined, which has been underlined. the division bench of this court has held that the power of the civil court cannot be deemed to have taken away, because what is bar under the act is the remedy of such action which are purported to, inverted comma, have been done under the act, inverted comma complete, and there cannot be any dispute with this general proposition of law as to what is barred under the offending section is the jurisdiction of the civil courts in respect of any matter, inverted comma, determined and decided by an officer or authority under the act. Inverted. The division bench of this court categorically held that the excise commissioner lacks jurisdiction to inquire, and if the petitioner and that the petitioner was at liberty avail his remedy before the competent courts of law. The present relief sought by the petitioner seeking for challenging the renewal of license is unsustainable, and this court is of the considered view that the petitions are devoid of merits, and accordingly the writ petitions stands dismissed. Yes, we could know 68 and all the provisions of excise act. Thank you, Senior. Petition, petition. Annexure, yes. Yes. Senior counsel, not another senior counsel. There are so many senior counsels. Yes. What happened? No settlement. Where is the part? Where is the advocate? Bandidara? Madam, we have to invite you to come to the court. So you don't want to come to this court? Have you paid the cost? He was here, your party was here itself. You have paid the cost, right? Yes. Now what is the proposal for no settlement? Failed. $20 guntas, right? You are giving. Then that was very considerable proposal by the appellants. If they don't want, they will not get anything. In the event this court holds in his favor, they will not get anything. Then that is what they gave, right? Proposal. What was the conditions you were in? See? Parties will say anything, madam. You have to take some initiative if you really want to settle. Just because of saying something, we should not say. Even the parties. These parties are there before this court from all the hearing dates. They are aware what is going on here. What they have instructed you, we don't know. What is that? What is that? No, now she would not have any much role in this. The other file for it. Chick time is bad. Together they'll get some share along with the plaintiff. Then what is her independent right? Chikkatayammas. In the event this court holds that they have contributed to the amount or they have paid the amount, what happens? He took so much pains to hear this appeal. Senior counsel argued, he was arguing. And then when proposal was made, we thought of telling you, we invited you to the court. We thought of, Chikkatayamma, defendant number 6. Parvatam, Lakshmamma is the plaintiff number 1. They are the Chikkaya's children. They say it is their self-acquired property. Only item number 9. They had paid that amount. Alva, you have paid that amount. So who has executed what transaction? Correct. This 10, see, if this 10 kuntas is of nil encumbrance, if there is of nil encumbrance, are you not entitled? Are you not ready to take it?
But we are ready to pay it. What they are saying is, over 84 where 2 is concerned, after soon of the decree, they have sold it. Someone, that's what they are trying to say.
But how is that concerned now to your problem? You are only.
But they are saying that directly they are not clarifying it. Simply, they are dragging on the bill.
We will hear this matter. I don't think they will be able to. This will argue in the afternoon, 2:30. 2:30. Party in person career. Really? Mr. Ramaya? Today. What is that? ಹೇಳಿ. ಇದು ಡೈರೆಕ್ಷನ್ ನೀವು ಹಾಕಿದ್ದೀರಲ್ವಾ? ಇದು ಕೊಡಿ, ಡೈರೆಕ್ಷನ್ ಇರ್ಬೇಕು. ಹೇಳಿ ರಾಮಯ್ಯ ಅವರೇ. ಹೇಳಿ. ನಿಮ್ಗೆ reinstatement ಆಗ್ಲಿಲ್ಲ. You are entitled for only terminal benefits from the date of dismissal till he attains the age of superannuation. ರಾಮಯ್ಯ ಅವರೇ, ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಆಯ್ತು, ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. ರಾಮಯ್ಯ ಅವರೇ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. ಏನ್ ಹೇಳ್ಬೇಕು ಹೇಳಿ. Ah. Yes, Hmm. Why the repetition for it? Remember. You have furnished him the copy of the synopsis. You have given him the copy. Kindly furnish him the copy. ಆಯ್ತು ನೀವು ನೋಡಿದ್ರಾ? ಆಯ್ತು ಎಲ್ಲ ಸುಳ್ಳು ಆಯ್ತು. ನಿಮ್ದು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಯಾವಾಗಾಯ್ತು? ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಯಾವಾಗಾಯ್ತು? 27. ಆಯ್ತು ಆಮೇಲೆ ಇದೆಲ್ಲ ಇದೆ ಇಲ್ಲೇ. ಎಸ್. ನಿಮ್ಗೆ 7,85,000 ಹೆಂಗ್ ಬರ್ಬೇಕು? ಹೇಗ್ ಬರ್ಬೇಕು ನಿಮ್ಗೆ 7,85,000? ಎಷ್ಟು ವರ್ಷ ನೀವು ಮಾಡಿದ್ರ ಸರ್ವಿಸು? ನೀವು ನೀವು 15,000 ನಿಮ್ ಸ್ಯಾಲ್ರಿ ಇದೆ ಅಂತ ತೋರಿಸ್ಲಿಕ್ಕೆ ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರ? 15,000 ನಿಮ್ ಸ್ಯಾಲ್ರಿ ಇದೆ ಅಂತ ತೋರಿಸ್ಲಿಕ್ಕೆ ವಾಟ್ ಇಸ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ ಯು ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್? ನೀವು ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರ? 15,000 ಹೆಂಗಿದೆ ನಿಮ್ದು? ಎಲ್ಲಿದೆ? ಅಲ್ರಿ 15,000 ನಿಮ್ ಸಂಬಳ ಇದೆ ಅಂತ ತೋರಿಸ್ಲಿಕ್ಕೆ ಏನ್ ಕಾಗದ ಇದೆ? ಹಾ ನೀವು 7,85,000 ಹೆಂಗ್ ಬರ್ಬೇಕು ನಿಮ್ಗೆ ಮಿಸ್ಟರ್ ರಾಮಯ್ಯ? ಹೆಂಗ್ ಬರ್ಬೇಕು ನಿಮ್ಗೆ 7,85,000? Yes. ಆಯ್ತಾಯ್ತು. ಇಲ್ಲಿದೆ ರಾಮಯ್ಯ ಅವರ ಇಲ್ಲಿದೆ. ಕೊಡಿ ಅವ್ರಿಗೆಲ್ಲ. Yes. Wait, hold on. ಇಲ್ಲಿದೆ ಇದೆ ಇಲ್ಲೇ ಇಲ್ಲಿದೆ. ಆಯ್ತು, ಅವೆಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ? ಇಲ್ಲಿದೆ. ಆಯ್ತು, ಹೇಳಿ. ನೀವ್ ಹೇಳಿ ಅಷ್ಟೇ. ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೇಳಿ ರಾಮಯ್ಯ. ಹಾ, ಇದು ಅನೆಕ್ಷರ್ ಸಿ ಬನ್ನಿ. ಅನೆಕ್ಷರ್ ಸಿ ಅವ್ರ ರೆಡ್ ಪಿಟಿಷನ್ ಅನೆಕ್ಷರ್ ಸಿ ಬನ್ನಿ. ಶೋ ಹಿಮ್ ಅನೆಕ್ಷರ್ ಸಿ. ಅನೆಕ್ಷರ್ ಸಿ ನೋಡಿ. ಇದು ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ? ಈ ಅಮೌಂಟ್ ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ? ಇದು ದುಡ್ಡು ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ? 7. ನೀವು 20 ಅಷ್ಟೇನಾ? ಇದು ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ ಈ ಅಮೌಂಟ್? 2010. ಯಾವ ಆರ್ಡರು ಅದು? ಲೇಬರ್ ಕೋರ್ಟ್ನವರು ನೀವು ನಿಮ್ಗೆ 42,781 ಅಮೌಂಟ್ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ 10% ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ರು. ಇದು ಇವ್ರು ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ 2010 ನಲ್ಲಿ. ಇದೇ ಗ್ರಾಚ್ಯುಟಿ ಅಮೌಂಟ್ ನಿಮ್ಗೆ ಅವೈಲೇಬಲ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಲೇಬರ್ ಕೋರ್ಟ್ನವರು. ಆಯ್ತು, ದಟ್ಸ್ ಆಲ್. Why? What is the urgency for tomorrow? Then you should move a memo at 10:30. We will not take memos in the afternoon until there is an extreme urgency. Is it not? Alva? If you move a memo, everybody will start moving memo at 2:30, 1:30, 4:30. We have to maintain something, right? Called the decorum of the court. No. If it is an extreme urgency, we will take it. Only for recalling. What were you doing for so many years? The amount ordered by the labor court, amount of rupees 42,781 is towards the gratuity. Where do you find it? On 687. That is. That is what 42,800.
How it is calculated, and this order has been page 42, section R7. Actually, page 47. For the sake of elimination, the page 46 is the last.
Yes.
ಮಾನ್ಯ ಕಾರ್ಮಿಕ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ಸಚಿವಾಲಯಗಳು ಪರಿಗಣಿಸಿರುವ 22/5/22 ಅಧಿಕಾರಿಗಳು ಪ್ರತಿ ವರ್ಷ ತೀರ್ಮಾನಿಸಿದ ವೇತನ ಪೆಟ್ರಿ ಸದರಿ ಪ್ರಕರಣದ ವಿಚಾರಣೆ ನಡೆಯುತ್ತಿರುವ ಬಗ್ಗೆ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ 2009ರಲ್ಲಿ ನೀಡಿರುವ ಆದೇಶದ ಅರ್ಜಿಗಳನ್ನು 2005ರಲ್ಲಿ ವಜಾಗೊಳಿಸುವುದು ಕಡಿಮೆ ಹಾಕುವುದರಿಂದ ಅರ್ಜಿಗಳು 2004-2009ರಲ್ಲಿ ವಯೋನಿವೃತ್ತಿಗೊಂಡಿರುವುದಾಗಿ ಪ್ರತಿವಾದಿಗಳು ವಿಷಯ ಆಸ್ತಿ ಉದ್ದಪಡೆ. ಆದ್ದರಿಂದ ಅರ್ಜಿದಾರರ ಸೇವಾವಧಿಯನ್ನು 1982ರಿಂದ 24/9 26 ವರ್ಷ 13 ದಿನಗಳು. So this is date of entry and the 9th date of retirement.
Now, against the order of this controlling authority, he has not approved.
And now if your lordship will come to page 48, page 48, the amount is calculated. So in terms of the act and in terms of the regulation. In terms of the regulations, it is for variation. So there 2,53,307 is regulation. And your lordship is writing up page 49. In page 49, the payment that is made to him is page 49. In page 48, the last paragraph. ಪ್ರತಿವಾದಿಗಳು page 48.
Yes.
ಪ್ರತಿವಾದಿಗಳು ಅರ್ಜಿದಾರರಿಗೆ ಈಗಾಗಲೇ ವಿಭಜನೆ ಮಾಡಿ 14,700 ಅರ್ಜಿದಾರರಿಗೆ 95ರಲ್ಲಿ ವಜಾದಾರ 2005ರಲ್ಲಿ ಅರ್ಜಿದಾರರು ಮತ್ತೆ ವಜಾದಾರ ನೀಡಬೇಕಾದ ಪ್ರತಿವಾದಿಗಳು ಅರ್ಜಿದಾರರು ಹೌದು 2009ರ ಒಂದು 2004ರಲ್ಲಿ ಆಧಾರದ ಮೇಲೆ ವ್ಯತ್ಯಾಸ ಮುಕ್ತವಾದ 2006 28/11/2005ರಲ್ಲಿ ದಾಖಲಾಗಿದೆ. ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯಕ್ಕೆ 2008ರಲ್ಲಿ ನೀಡಿರುವ ಆದೇಶದ ಅನ್ವಯ 82ಕ್ಕೆ ಸೇರಿರುವುದಕ್ಕೆ ಪೂರಕವಾಗಿ ವ್ಯತ್ಯಾಸದ ಉಪದಾನ ಮುಕ್ತವಾದ 50,816 ರೂಪಾಯಿಗಳಲ್ಲಿ 28/7/2008ರಲ್ಲಿ ಪಾವತಿಸಿದೆ. ವಿಷಾಣೆ 6ರ ಭಾಗ 2ನೇ ಪುಟ 13ರಲ್ಲಿ ವಿಷಾಣೆ 6/6 ದಾಖಲಾಗಿದೆ. ಮತ್ತು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು 2009ರಲ್ಲಿ ನೀಡಿರುವ ಆದೇಶದ ಅನ್ವಯ ಅರ್ಜಿದಾರರನ್ನು 2005ರಲ್ಲಿ ವಜಾಗೊಳಿಸುವುದನ್ನು ತಳ್ಳಿಹಾಕಿ ಸೇವಾ ಸೌಲಭ್ಯ ನೀಡುವಂತೆ ಆದೇಶಿಸಿದ್ದರಿಂದ ಅರ್ಜಿದಾರರು ವಯೋನಿವೃತ್ತಿಗೊಂಡಿರುವುದನ್ನು ಪರಿಗಣಿಸಿ ಅರ್ಜಿದಾರರ 25 ವರ್ಷಗಳ ಸೇವೆಗೆ 1,33,933 ನೀಡಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಆದರೆ ಪ್ರತಿವಾದಿಗಳು ಈಗಾಗಲೇ ಅರ್ಜಿದಾರರಿಗೆ ವಿಭಜನವಾಗಿ 4,935 2005 ಹಾಗೂ 1,33,2020 ಒಟ್ಟು 2,10,526 ಪ್ರತಿವಾದಿಗಳು ನೀಡಬೇಕಾಗಿರುವ 2,50,526 ಒಪ್ಪಂದವನ್ನು ದಾಖಲೆ ಪಾವತಿಸಿದ ಬಾಕಿ ಉಪದ ರೂಪಾಯಿಗಳನ್ನು 27,780 Because they could have given it. But the date of entry into service till retirement, entire amount is collected. That's whatever that is paid, deducted. I was directed to say, what is it's calculated as page 50. You also put up to page 50.
This is towards the gratuity amount.
It was also collected.
Now, against the controlling order, there's no appeal. There's no. And he has sought for recovery of this amount itself. And without bringing to the notice about the order which has been passed off by the labor court.
One order, I before you launch, either me or him, order, subject matter is the application deduction.
33C.
Ultimately, the same of 7,85,000, 42,781.
So was it towards the gratuity amount itself?
And I read it to your lordship in see to there's a discussion that this amount belongs to the order passed by the assistant labor commission. And the report comes to the conclusion, if you have not paid, you pay. Then this payment, I got it to the recovery officer. Recovery officer says, this is not gratuity amount, this is different.
So you are aggrieved by the order of recovery which has been directed against you when you have already paid that amount, and he says this amount is different from the amount which has been directed by the labor court.
So which means the order of Secretary CG has come to an end. So now to show that how is entitled to 7,85,000, I have given the calculation because there was a direction earlier. Premium on par with Mr. R. Lingaya.
Correct.
The option was open to me. I could have given it that is 2004. Because 1984. Because Mr. Murthy was brought in 82. I gave him the option of 82. I gave him paid by registration. If I got it to your option, A is from 82 to 91.
Yes.
82. He cannot in from 91 to 2005. 2005 is different to 2000. So because that calculation is only from 91 to 2005. From 2005, I did not have to pay any back payments.
Because he was dismissed from service.
Dismissed and the order of the expedition is without back payments. So therefore, the back
which is that order of this court wherein it says no back wages from 2005.
Transaction are 12, page 56. Page 57. The preamble, this is what I expected. Belongs to the theory. 56. 56, the first page is 87. For the same with regard to that, it is page 57.
Yes.
This repetition 556. To implement the order allowed to grant arrears of pay of 1 lakh, medical leave, and expenses amounting to 1,000, uniform, jerseys, etc., allowances of 4,000, and 213 flat payment of 4,000. But as far as 8757 is concerned, that was against the order of dismissal, where the dismissal order was confirmed. Then the order will court dismissed this case. The first case is dismissed. If your lordship could see page 67, paragraph. Accordingly, WP 8757 is allowed in part, but dismissing the WP 8337. 8337 is the claim towards uniform allowance. There is a consequence.
Correct.
Then you cannot be filed an expedition interpleading only against the lordship could come to page 69. There is a reference in the preamble, page 69.
Is against the dismissal of WP 43 8337.
Uniform,
correct.
And as far as his denial of back wages and other benefits is concerned, that the order of the expedition is filed. We did not question the order of expedition denying the back wages.
The denial of back wages for the period he has not worked. So he is not entitled for that from 2005.
Now with regard to this particular option, exactly the same. 7,85,000. 7 lakh 85,000.
That's
From 2080 and arrears of salary from 84 to 2009 till retirement. The first one, not A, plain statement. Plain rate. First one is 1980 and 2009 arrears of salary. Started as it is from
82 to 91 he seeks. Arrears from 82 to 91 one. And then B1 is 91 to 2005. And then
C is the gratuity.
So
B is not even gratuity.
so only A and B is agreed with. That is. Where is that?
I've extracted page. Page 1687. I've extracted from his page statement. The first one is 1980 and 2009 arrears of salary from 84 to 2009 till retirement. It carries no meaning, but I have to say whatever it was there, in the statement.
He would not be entitled for that arrears or any benefit. Benefits he is entitled, but not the backwards.
Then 4 lakh 65. Then consequential benefits for salary, bonus, CMPD, CL pension.
That has all been rejected.
Then monthly benefits, substantial benefits 85,000. Nothing is granted.
Yes.
And then the interest at 18%. He comes to 7 lakh 80. Notwithstanding this, we understood his claim is from 82 till 2009. So from 82 is the date of entry into service as done in Krishnamurti. Up to 91 he was working as a buddy. He was not granted the regular salary. Therefore, the regular salary is calculated and minus whatever that was paid during budget. 10,916. The second one B, if your lordship would come to there's a large difference. He gets about 1,45,000 by way of arrears in B.
Yes.
And C is the gratuity. As determined in annexure R7 by the controlling authority. The last one, the maximum period is 240 days.
Yes.
Any person with any employee, then 240 days maximum. Maximum is calculated. And that is also paid. And all the check payments encashed by him. But I have understood. Along with my section statement, take your lordship to page 39. Page 39. Page 39, payment A 10,900. He assigned and taken the check. Then annexure R5, page 40. This is B amount, capital B. The last one, 1,45,000.
Yes.
Next, R50, B amount.
Yes.
Annexure R6, page 41. Is B amount, 93,879. That is the sixth item. Item number 6. 98,879.
Yes, yes.
That is B. And as far as P is concerned, the difference in amount.
Yes.
That is reduced. It is only reduced. And it comes to annexure RA. By way of check, 45,668 was deposited to the controlling authority. Because I
You
cannot pay.
produced it in the writ petition of use. This is this annexure?
Annexure RA. And page 55. Page 55. This is encashed period. This amount is encashed by assistant labor commissioner. Page. Yes. Annexure R11. About ninth item. After the GMAX will shows the show as assistant labor commission. And the payment that is made reflected with this photograph. The other reflection annexation. So our A plus B plus C plus D payment is very good. Therefore, I think it satisfied the labor code and then section 33C declined to grant the amount which is claimed.
ಇಲ್ಲಿದೆ ಆರ್ಡರ್ ಇದೆ. ಎಸ್. Heard reserve. Heard reserved. Yes. 7 ನಾರಾಯಣ ಸ್ವಾಮಿ ಇದು ಈ ಲಿಸ್ಟ್ ಬನ್ನಿ ಆರಿಸಿ. $230 ಯಾವ್ದಿದೆ? ರಿಸರ್ವ್ ಅವ್ರಿಗೆ ಹೇಳಿ ರಿಸರ್ವ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ. Yes.
Further hearing, C-29 case number 29, Sri Krishnamurthy G.
The further hearing matter, senior counsel will take your matter tomorrow. Tomorrow at 2:30. 2:30. Because we are this court is sitting only till 3:30, so we'll complete this. Although, your serial number, which is your serial? 9. 5 further hearing tomorrow at 2:30. ಆಮೇಲೆ ಇನ್ನೊಂದು ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಇದೆಯಾ ಗೌರ್ಮೆಂಟ್ ಆಳ್ವಾ ಅವರೇ? ಆಳ್ವಾ ನಾಳೆ ನೀವು ಮಾಡಿ. ವಿ ಆರ್ ಹಿಯರಿಂಗ್ ದಿ ಅಪೀಲ್. ವಿ ವಿಲ್ dispose it of tomorrow. Yes. ಆಳ್ವಾ ನಾಳೆ tomorrow at 2:30. You file it in the registry, we will see. Ramaswamy Iyengar, serial number 7. This also tomorrow. Yes, we have heard this. Who sued boss? Now not at this stage. Consent deed, and what is the validity of that consent deed, Mr. Counsel? Is it registered? No, you don't just make submission. We will see tomorrow. Not further hearing. Mr. Counsel, we have already heard you. Tomorrow tomorrow. The council, you know, Monday what matters we take. Tomorrow. Yes. Others, any other matters which matters, which, any urgency, any matters? Tomorrow, all these matters will be listed tomorrow. So tomorrow. Serial number 9 ನಾಳೆ ಎಲ್ಲ ರಿಪೀಟ್ ಮಾಡಿ ನಾಳೆಗೆ ಸೇಮ್ ಲಿಸ್ಟ್ ಇಷ್ಟೇ ಹಾಕ್ತೀನಿ. ಎಸ್ ಎಸ್ ಮಿಸ್ಟರ್ ಕೃಷ್ಣಮೂರ್ತಿ ಅವರೇ ಇವತ್ತು ಮುಗಿಸ್ಬೇಕು. ಎಸ್ we have sent everybody only to hear your matter. Yes. Oh, this is for dictation alana. You will get a right only if the respondent gets some right, right? Then what is your right there? You were the list pendants. They were heard. Who said they were not heard? Who said they were not heard? Kadri was here. You can't make a submission. We have heard you, right, Mr. Kadri? And she makes a submission that we have not heard you. What type of submission is this, madam? We are making submission on his behalf. He is very much before the court. He has said that he is heard. How can you say that? You were not there when the matter was going on. Were you there? Then have you not heard you? Allah, have you not heard you? Then what is her role? Mr. Kadri, what is her role in this? What is your role? And how can you make a submission? We have not heard him. Now, how can you make such submission? We can understand if we have not heard you. No. Her right would be only if you get some right in this. If you are not getting any right, she will not get any right. We will not say anything. Then we will dictate it now itself. No, we will dictate it now itself. Then. No, what is that? No, whichever senior comes on the earth, can they change the facts? You should make some genuine submissions, madam. You should know what is going on before the court. You should be present when your name has been indicated in. No, your name should. How can you hear somebody and tell something? Who is your colleague who told you that? Who is your colleague? Ask him to be present. Is it proper on your part to make a submission that we have not heard him? Is it proper, madam? She'll take that. No, we will not hear her. No. Yes, ma'am. Yes, sir. All matters tomorrow. Yes. So you're testing our patience. Not very fair on your part. Not fair. Yes. We will not hear such submissions, madam. When this court hears everybody, each counsel, and you make a submission. Yes, I hear it. Yes. Your suit is for specific performance. Specific performance. Correct. Then a note.
Oh, Dina. How that big? They got to the other pass on this regarding
just refresh something. Just refresh ಮಾಡಿ ಏನಿದೆ ಅಂತ.
I think
not all that, only just what is your suit, we will understand. You're the plaintiff. Synopsis you have filed, right? Synopsis for you. Synopsis nalline notes ಮಾಡಿ.
Stated everything. I would request this court to look into it. So also the
ತುಂಬಾ ದಿವಸ ಆದ್ರೆ ಹಿಂಗಾಗುತ್ತೆ. Yes, ಇದೊಂದು ಸ್ವಲ್ಪ ಕಟ್ ಮಾಡ್ತೀನಿ.
after the file of consideration filed on 16 plus the zeros. The letter and what is here.
Just a moment, huh? Just. ಹೇಳಿ ಇವ್ರೆ ಹೇಳಿ ಅದು ಸಿನಾಪ್ಸಿಸ್ ಕೊಡಿ.
Who is filed in 7 of 1987 was filed by me.
For specific perform. Let me tell the facts like this. Plaintiff is the appellant in RSA 9 of 2016, wherein you filed a suit for specific performance of contract on an agreement dated 14/5/1995.
Yes.
And in OS number 318, you are the defendant. Alva? And that is the appeal preferred by you in RSA 8 of 2016. The
Yes.
Sarojama, who is the purchaser, Alva?
Yes.
1912-1998. He is seeking for possession of the property. You were the tenant earlier.
My father-in-law.
Father-in-law was your tenant, was the tenant. And subsequently, it appears that according to you, there was an agreement. And in light of this agreement, you are in possession of the property and you have to be protected. In 53A, that is your contention.
And my submission is the possession of the appellant pursuant to the agreement, Exhibit A, is virtually supported by the evidence on record, by the evidence of both Sarojama and DW one Deepak, who is the son of Krishna.
Firstly, you were in possession as per a tenant, as tenant. HRC proceedings concluded. Execution, you say that a memo was filed and it was held, it was settled, or it was execution petition was withdrawn. No?
Symbolic possession.
So he said he has taken the possession. So the execution petition came to be closed. You said, as on the date when execution petition was closed, you had already an agreement, but agreement was not brought to the notice of the executing court. Why was it not brought? That is unknown to anybody.
So that's because of the fact that Krishnadas admittedly allowed me to continue in possession of the property pursuant to this agreement. At the time of giving evidence in the matter, Krishnadas was not available. He had died. He did not, he could not deny his signature on Exhibit A. Rather,
But see, then one thing comes to the mind of the court. When an agreement is being executed, the Krishna, who is it? Krishnadas would have told the court, no, do not want to press this execution because I have settled. But Krishnadas then did not make any submission.
Submission.
Neither you made a
ಏನ್ ಮಾಡಿದ್ದಾರೆ ಈಗ document exhibit P8 and P9 the alleged
execution
delivery Swagin Patra said.
Now can we look over the execution petition order when it says there is a possession delivered?
But submission is there are specific admissions made by DW1.
One is document, one is evidence. What is to be waived? Which is
it is admission by son of Krishnadas. That we were in
that son was not even there at that point of time.
But he said he was there. He was there. He was there. I will take
How much weight do you have to give for the evidence of the witness, and the document has to be considered, and that to a court document.
But the courts have proceeded on the basis that this agreement exhibit PA is not sufficiently stamped. That is one ground. Second ground is that the signatures of Krishnadas do not tally with some of the other documents on the record. The court itself compares the signatures. And the court, mainly on these two grounds, the exhibit DA, the agreement is displayed. And the lower appellate court does not consider any other material available on the record. Only on the ground that exhibit signatures on exhibit DA do not tally with the wakala signed by Krishnadas. It holds that it is only on the Baki house considered. In fact, that is one of the questions of law framed by this court. And interestingly, I was reading that
Substantial question.
So
you answer the first substantial question of law on that. Let us go on substantial question of law, because many substantial questions of law have been framed. Alva?
Question of law. Once it is proved as a nullity and proved as not specific or further question of law.
Yes. Kodi. So you answered this first substantial question of law. Whether
I told that you are not wanted to know on 3-9. I was reading the other part regarding the admissibility of the agreement of sale dated 14/5/1995, executed by Krishnadas, and the court had passed the order on 23/10/2010. It was not found in the records on that day. It is part of the record in OS 318 of 99. Swarpada Kodi exhibit D8 ಮೇಲೆ ಮಾಡಿದ order. ಅಡ್ಡ flag ಹಾಕಿದ್ರು. ಆ order that is not considered by the courts below. They wanted the lordship wanted to know whether that order has been considered by the trial court or the lower appellate court. But the thing is that trial court proceeds on the basis it does not consider that order.
Original series.
It is not considered by the trial court at all.
But if you have paid the deficit, see, the question of admissibility is one thing. Question of execution is one thing. Admissibility of document is between the court and the witness, and now the document is being impounded, and it was subsequently you have paid the penalty. So now they admitted in the evidence. Fine.
And one point.
Whether there was an execution. No, we have understood that order now.
Trial court proceeds on the basis this is an insufficiently stamped document, so it is an invalid document. Because there is no application of fine by the trial court and the lower appeal court. 90C, para 30. ಅದು ಒಂದು ಇದಕ್ಕೆ ತೋರಿಸಿ ಬಾಕಿ ಬರ್ಕೊಡ್ತೀನಿ. para 30 of the trial court judgment. Yes, page 225, para 30. Page 225 of that paper book. 225.
Yes.
Because that is one of the grounds on which the document is not considered or disbelieved. It is also pertinent to law, to lordship document.
Yes, yes.
That under Exhibit DA, the possession is handed over on the date of document as per the recital of Exhibit DA. The said document is an unregistered document written on stamp paper of ₹50 only. It is well settled principle of law that in case the possession is handed over under agreement of sale, then document is to be registered and the stamp duty has to be paid as per the Karnataka Stamp Act on the market value of the property. The said document is an unregistered document stamped as per law. E-order that is not considered by the trial court. And the lower appeal court, it is not a judgment at all in accordance with order 40 or rules.
No, though it says regarding the admissibility of this exhibit D8, an unregistered document, but the transport goes as though it is there. Exhibit D8 is there, and whether it has been duly executed anta ಹೋಗ್ತಾರೆ. ಅಲ್ಲ, technicalities it has said something about it, but it did not discard your exhibit D8, but it looked into the relevance of exhibit D8 and whether there is a valid execution. No, not only on admissibility, it has proceeded on the ground about the execution, whether there was actual execution by. Yes.
Now, so far as this court comparing the signatures, that's also one
That
of
is not barred totally. The court can look. Alva.
Judgments on the point. Having not the fact circumstances involved in the case. And in view of the fact that the signature of Krishnadas has not been denied. And
I think Mr. Hassegar, your knowledge, your applicability to this facts, no, you should apply it to some better case than this case.
No, I think this is my submission is this is the ideal case in which I can make use of the same. I will take your lordship through the judgments on the point, having regard to the fact that the signature, the document, while marking the document through DW3, it was not objected on the ground that it is not signed by. It was objected to on the ground that it is not sufficiently stamped. That point your honors may kindly ignore. Signature is denied madila. Had the signature been denied at the time of marking the document, because you are not 39 put a question. Why Radha, the appellant, did not make any application to refer handwriting expert? First thing is, it was not objected to on the ground that it is not signed.
They disputed that document itself, right? In their written statement. Object ಮಾಡಿದಂದ್ರೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಯಾಕೆ ಆಬ್ಜೆಕ್ಟ್ ಮಾಡಬೇಕು? ಮಾರ್ಕಿಂಗ್ ಗೆ ಆಬ್ಜೆಕ್ಟ್ ಮಾಡಬೇಕು because it is not admissible in evidence. Signature ಇಲ್ಲ ಅಂದ್ರೆ dispute, you can't say, you can't mark it ಅಂತ ಹೇಳಲಿಕ್ಕೆ ಬರಲ್ಲ. That has to be marked, and then he is disputing that signature of his. It is very in a narrow compass. You are making a distinction between that aspect.
Krishnadas was not available to deny signature under section 73
Okay. Now
had
the
been allowed.
burden was on you to prove that there is an agreement. So how will you prove that agreement?
I have examined DW3.
Then when the signature is disputed, they said that Krishnadas has not even signed that document. The burden was on you to prove that this is the signature of Krishnadas. What efforts did you make to prove that his signature on that document?
He did not file an application for referring and handwriting itself because the signature was not denied at the time of execution.
No, that is not required. That law doesn't say signature has to be denied at the time of execution.
Its second reason is, when we see one original records, we kindly see. That is the executed document. Exhibit P1.
P1, you know,
The same deed
in favor of.
executed by subsequent same deed executed by Krishnadas during the pendency of the suit for specific performance. After the matter was filed, suit for specific
See,
performance.
once then agreement is held not proved, everything all follows. Whatever is sale deed, whatever is there. You're not come to the court saying that the sale deed is not proper or anything. You are seeking for your execution of an agreement. You're before the court seeking for an agreement for execution of that agreement and execution of a sale deed.
My submission is this sale deed may kindly be seen.
How is it relevant, Mr. Hasegara?
To show that the signature of Krishnadas, even in this admitted document, they do not tally with each other.
Then you would have given a best piece of evidence by referring the matter to the forensic laboratory.
Kindly see the document. There was no occasion for me to file the application because the signature they do not exhibit P1. One signature tally agadiದ್ರೆ I could have filed an application.
That is why the court looked into all those documents and said that.
Kindly see exhibit P1. The admitted document signed by Krishnadas in favor of Surajamma subsequent to the filing of the suit OS 507.
Yes.
I will not got that document.
Yes, it's here.
Kindly see the first I would take your lordship through the averments made or the contents of the document because it says, may I read that document?
Yeah, this is an admitted document. There is a sale deed.
Admitted document. It says physical possession has been handed over to the purchaser.
That is one aspect.
Physical possession has been handed over to the purchaser. But the purchaser says, no, physical possession was not handed over, only symbolic possession was handed over to her. And the theory made of her by is that subsequent to Krishnadas taking possession in the execution proceedings on 6795, Radha forcibly entered into the premises, and that is how she is in possession of the property. That is the theory put up by Srimati Sarojama. That is totally falsified.
That is the suit for possession now.
Yes, but the thing is,
you just one question for you. How much protection you require under this 53A?
No, I do not say that my possession is protected under section 53A. That is why we see an order of injunction. No.
Then
that is the suit is for specific performance.
Correct. Your suit is for specific performance. You seek protection under 53A, saying that you are put in possession in light of the agreement, and the possession has not been delivered to the purchaser. So how do you protect your possession? Now, in the event, this court says that the agreement is not proved and there is no agreement in your favor, what happens? The possession has to be delivered to the respondent who has purchased the property.
But the thing is, having regard to the fact that Srimati Sarojama purchased the property during the pendency of the suit filed by me, and when Krishnadas was aware of the suit and the interim order granted by the trial court, whether such a stay, that is also one of the questions. And section 52.
If the vendor gets title, the purchaser will get title. Alva. Ashte law though. Why are we deviating from the settlement?
No, thing is, if Sarojamma did not get possession of the property, she will have to show that subsequent to
Possession of Sarojamma, possession of Krishnadas is evident from the execution.
no,
EP.
execution no, P6, P8 and 9, they do not say that possession has been delivered by the judgment debtor. No, it says, I am taking a lordship through that. It says, B mane ಬೀಗ ಹಾಕಿದ ಮನೆಯನ್ನು ಒಡೆದು ಸಾಮಾನನ್ನು ಹೊರಗೆ ಹಾಕಿದ್ದಾರೆ.
That is how the execution takes place. If they don't deliver the possession, they have to take recourse to law.
But the notice will have to be served on the LRs of Puttaswamy.
We have not challenged that execution order, whether it was proper, not properly executed. Have you challenged that?
I say that pursuant to that, possession has not been delivered.
When was the execution closed?
1995.
95. You are in possession from 75. 72, no? 70? 72. 72.
Kindly see this
Where you stand.
Krishnadas signature.
You have completed successfully 50 years of independence.
On the basis of exhibit A. Only on the basis of exhibit A. ಆಗಾಮಿ ಕಾಲದಲ್ಲಿ 70,000 ಈಗಾಗಲೇ 40,000
ಆಯ್ತು ರೀಫಂಡ್ ಮಾಡಿದ್ದಾರೆ ಇದರಲ್ಲಿ ಅಗ್ರಿಮೆಂಟ್ ಇಸ್ ಹೆಲ್ಡ್ ಟು ಬಿ ನಾಟ್ ಪ್ರೂವ್ಡ್ ಅಲ್ವಾ ಅಗ್ರಿಮೆಂಟ್ ಇಸ್ ಹೆಲ್ಡ್ ಟು ಬಿ ನಾಟ್ ಪ್ರೂವ್ಡ್ you have not even paid rent after that no rents have been paid
because
you are the possession of the property as the owner or the proposed owner so that amount which you have paid according to you was to be treated as a rent then.
Now, kindly see exhibit P1. The signatures may kindly be seen.
Now ಯಾಕೆ ನೋಡ್ಬೇಕು ಅದನ್ನ why should we look into that signature because what mistake the trial court according to you has been done you want this court also to look into the signature and find whether it is the of the same person we need not go into all that aspect.
The signature. How to tell you?
We are not going to go into that exhibit P1. New exhibit D8, how do you establish that there is an agreement?
My submission is having regard to the evidence.
Evidence really, then we will conclude.
Yes.
Let us not go into other aspects.
Yes. Now, so far as this first, before I go to that, I have filed an application. IA 1 of 23, requesting this honorable court to frame substantial questions of law, additional substantial questions of law. That we kindly receive.
What is that additional?
Apart from the questions of law framed by this honorable court. IA 1 of 23. On 71/16, this honorable court has framed substantial questions of law by a detailed order.
ಅದು ಬಿಟ್ಟು ಮತ್ತೆ substantial question of
ಅದು 4 questions of law ಬರ್ತಾವೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಹೇಳಿದ್ದೇನೆ. Page 2 of that application. Whether the judgment of the lower appellate court is in compliance or in accordance with Order 41 Rule 31 of CPC, and the same can be sustained in law. Earlier, in view of the specific admissions made by DW1, Deepak, son of Krishnadas, saying that his father was aware of the suit, OS 507 of 1997, for the specific performance of the agreement, Exhibit D8, that there was an interim order granted in the said suit, and that 11 months after institution of OS 507 of 1997, the sale deed Exhibit P1 has been executed in favor of Srimati Sarojamma. Whether the registered sale deed dated 9/12/1998.
How is it relevant? How is it relevant?
Because section 52 comes into play. When
List pendants.
No, when there is an interim order granted by the court.
We are not seeking for any action against them. We are not seeking for any contempt of court. No, not necessary. Then anyway, while answering all these questions, this all will come into while we are answering all this.
When there is an interim order granted in OA, if the sale deed is executed in violation of the interim order, whether such a sale deed can be said to be in accordance with law. There are judgments of the Supreme Court on the point. And the evidence, specific admissions, I will take your lordship's evidence.
ನೀವು 3 ದಿವಸ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಇದನ್ನ ಎರಡು ಹಾಕ್ಲಿಕ್ಕೆ ಬರ್ಲಿಲ್ವಾ ಅವಾಗ ಸಬ್ಸ್ಟಾನ್ಷಿಯಲ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ
ಆಗ ಸಾಹೇಬರು ಇದನ್ನು ಮಾಡಿರ್ತೇನೆ if necessary at the time of hearing additional questions of law.
We will only frame first one that is whether the first appellate court has followed the procedure as contemplated under order 41 rule 31.
ಅಲ್ಲ ಇನ್ನೊಂದು question
That is not a question of law. That is not a question.
Section 52 violation of section 52.
Violation, you are not before this court against violation of any order. No.
If the sale deed is executed in violation of the order granted by the court, that is a document which cannot be relied upon. That cannot be upheld by this court. He is the judgment of this.
According to you, then there was an interim order. They have sold the property, and the sale in favor of so and so person is not
invalid. Is invalid. That is the point. And there are judgments.
Future. Page 26, huh?
As finance, the financial is that by showing the round that the status quo order has not been served upon the secretary and subsequently after 11 months of constituted John immediately showing the character. Thereafter the notice has been served upon.
But his son Deepak specifically admits that his father was aware of the order. And see, discretionary application 52 to 84 is the evidence given by Deepak. And he specifically admits. I would discuss this on the
We will continue tomorrow. Tomorrow at 2:30. ನಾಳೆ 2:30. ಇದಾದ್ಮೇಲೆ ಅದು ಹಾಕೊಳ್ಳಿ. Yes, you were not there, Mr. Subramanya. Monday. Dictating orders now. Dictation. No, second appeal we will not take it on Monday, tomorrow. Yes, the other matters tomorrow. Other matters tomorrow. ನಾಳೆ ಲಿಸ್ಟ್ ಮಾಡಿ ಇದನ್ನೇ ಎಷ್ಟು. ನಾಳೆ ಕಾಫಿ.
ಫೋನ್ ಮಾಡ್ತಾ